Mr. Sahoo, I will take after vacation. Susan Marshall.
So Behra, you don't have power here.
No, my lord.
You are Mr. Upon Puranada
Pratap Kumar Behra.
P.K. Behra.
Ma'am.
Pratap Kumar Behra on behalf of S.K. Sahoo for the petitioner. Matter being listed for fresh admission is mentioned at the beginning of the day's proceeding for adjournment, seeking adjournment. Stop. To grant further opportunity to the petitioner, list in the week commencing. On 6.
Item 2, my lords. May I pray?
Mr. Raut,
My lords, item 2, may I pray after vacation, my lords?
Mr. Mohanty,
No, no.
upon opposite parties.
Yes, sir.
Adjournment council. Same order. 2 re same order. Rajendra Narayan Raut for the petitioner. 2 re Mr. Lenkana upon.
I'm
So P.K. Mohanty AC for the opposite party. So mention date केवे है?
29.
29 अपन 29 रे 50 टा पहुंचले सेंसर देखि करी.
Item 4, my lord.
4
For I pray for next week. And for the petition.
ने अपन को 3 सर्वर. Next week आपण कहीं चाहू ना जी कोन असुविधा अछि फ्रेश एडमिशन
Out of station.
सार आउट ऑफ स्टेशन सीपीसी रे प्रोविजन टा अछि ना ना ये पर स्पेसिफिक प्रोविजन प्रोवाइड करे जी द लॉर्डेड काउंसिल बिंग पीजी एंड फेयर ग्राउंड अदर साइड को कन्फर्म कर दीजिए सेम आपण को ना सर
Person Kumar Barik.
पावर अछि पीके बारिक फॉर द पिटिशनर अपोजिट पार्टी के अछंती अपोजिट पार्टी ब्लैंक कर दे same order mentioned है and fourth mention after date matter being in the list listed for fresh admission जहाँ लिखते हैं ये पे date कर ले
वो कौन से 29 है?
we commencing on 29
Phase 2 6 to 15.
My lord, item 8, my lord. My lord, item 8, I humbly pray, my lord, I may be permitted to amend the application and file a consent.
permission दरकार नहीं अपन फाइल करिए पड़ियो oral permission रे हुए नहीं
My lord, I'll file it
must
and
understand that
my lord.
always make a proper and perfect summation अपन submit यदि other side appear करते हैं copy serve करिए
No, my lord, it's for fresh
and
admission.
move the application
My lord.
पर adjournment चाहूँ
My lord, yes, I'll file the consolidated.
consolidated allow hela pore
My lord.
My lord,
Mr.
item,
Parth Agarwal for the petitioner. The matter was heard at length on 26/3/2026. The matter was earlier listed on 18/2/2026 and 26/3/2026. The add up. That the matter being listed in the list and so also for the Purana lecture to grant further opportunity list in the week commencing 6/7/2026.
Great.
pardon for mentioning, my lord.
Yes.
Item 10, my lord, may kindly take up this matter after revision.
The matter being in the list, the matter being listed for fresh admission, to grant further opportunity list in the week commencing 6/7/2026. Yes, next.
Phase 3.
Page 3, my lord, item
21.
number 18, my lord. Page 3, item 18, my lord.
18.
My lord. I pray, my lord, on behalf of Mr. S.B. Mohanty to take up this matter after lunch, my lord.
सेमती मेंशन करो तो पढ़िला बेले पास ओवर हो
Again,
बुझले ठीक है
thank you.
आपण करिया को चाहछथि तो
हाँ, Mr. Mohanty, मु सालेपुर आसी टाइम है जे मु लंच पर करिवि.
ठीक अछि ठीक
आज्ञा आज्ञा
सालेपुर आगुरु 2 घंटा लागुतला कटकरु सालेपुर 2 घंटा के जाइछथि आगुरु
आज्ञा.
when I went for the Salipur for the first time it took 2 hours I was surprised
My lord.
My lords, item 21.
21.
My lords. My lords, by order dated 11/3/2026, my lords had directed the DSGI office to get the salary particulars of the present petitioner. My
আরে
lords.
পড়ুন তাহলে, সেটা তো
My lords, my friend is my
Well,
senior is
but-
there, but the it is not received. So that is the reason I.
କେବେ ଆସିବ
After that is no.
କେବେ ଡେଟ୍ କରିବେ ଅର୍ଡର ପାସ୍
will council 13/7.
13/7.
Yes.
Oblashments. Interim orders, if I need to cut.
Yes. But that order will be passed when it reaches. Order has to be passed.
Manner.
Short for orders.
My lords.
Yes. That's why.
Item 29, my lord.
अच्छा ते पेज को जाए.
Page 4, 22 to 27.
22 to 27.
Lordship, item number 25, Your Lordship. It has
Yes.
two TRPCs, Lordships, between the same parties. One, by the order of this honorable court, the matter was referred to mediation. The parties have arrived at a mutual understanding. An agreement has been filed, and mediation report is also available. Along with that, a withdrawal memo has also been filed. So I pray, my lords, both the cases may be disposed of as withdrawn, so that, my lords, they can stay orders.
In the past matter, who is you are for the petitioner.
Petitioner and for opposite party also, my lords, counsels.
Your name, madam?
SL Sinha.
SL Sinha, yes. Along with Ms. Subhalakshmi Devi. Second matter, Chiranjeev is there, and opposite party you have not filed app.
No, Lordship.
You should have filed. Can I record that you have instructions?
Yes, Your Lordship.
Can you file the wakalatnama? Na duro jaga court pe
Puri, Pipli Road.
you should have filed. ठीक अछि, you have instructions. So that order will be passed, disposing of.
Lordship.
Yes, next.
28 my lord. I am
27 ভিতরে আপনি না দিন। ঠিক আছে।
Page 5, 28 to 30.
29.
29.
28 my lord. I am for petition. 28.
Petitioner senior counsel को inform कले। ଆପଣ opposite party, ଆପଣ petitioner.
No, I am for petition.
ଆପଣ opposite party का।
On behalf of Mr. L.K. Madhuri.
So PK Mahanti, you are there in 29.
No, it is Mr. Sethi. Ansuman Sethi.
29 is simply date करते हैं।
28 my lord. 28 my lord.
I'm sorry,
28. Mr. Sethi is there.
28 date कर देले होता है।
28.
Date कर दियो।
After vacation.
We council 27.
तापर
Item 29, my lord.
29, yes.
I pray for adjournment, my lord, because I received rejoinder, my lord, to file reply, my lord. 7 days time may be granted to file reply.
Other side inform करे दरकार।
Already fine, I senior to inform, my lord.
Petition.
He said, requested me, I cannot have, I understand the plight, but what I pray, my lords, it must have a priority because of this is 2013 matter. So your lordship may fix up an early date. Suppose
So what is happening, if you can mark please, 28/2011, 29/13. The computer is listing mechanism is like that. It is going up, but obviously after orders.
yes,
It is in fact second matter in the after notice system. So you want after or before vacation?
this is also after notice.
After vacation or before vacation?
It depends how much time.
I'm only 2 weeks time to file.
So the vacation है ना?
My lord.
ये after vacation only date को नहीं परियो? वोटा date देवे दियो तो जो
We
available।
council 29.
29/6.
Oblige, lord.
On this circle,
Yes.
Oblige.
Page
I'll
6,
pass the order or simply adjourn कर देले होगा?
Simply adjourn, my lord.
order to
ठीक है सर, ऑर्डर कर दो। ऑर्डर डिक्टेट करिए। ଆପଣ ଦେବେ ରିଜଏଣ୍ଡର କହୁଛନ୍ତି।
Rejoinder reply.
ରିପ୍ଲାଏ ଟୁ ରିଜଏଣ୍ଡର
Well, required more, only short.
ଯାହା ବି ହଉ। ଓକେ।
page 7, 31 to 35. Page 8, 36 to 39.
ବ୍ୟାଚ୍ ମ୍ୟାଟରଟା କଭର୍ଡ ମ୍ୟାଟରରେ କେହି ନାହାନ୍ତି। 30। Yes.
Item 3.
Yes, please. Other side, Mr. Samantre,
Yes,
you are there.
yes,
Second matter, you are the petitioner.
yes. I
Yes.
filed for enhancement. Now my friend has filed this challenging the.
Can anything be worked out, Mr. Samantre?
What can be worked out if he agrees with us? Where he's,
You have to make a lot of effort.
no, in fact,
This
he has
is,
to make a lot of effort because I am the wife.
My understanding is it is much easier said than done. And I am giving you, both of you, a difficult task. You can work out, it will be, I think something can be. What yes, Mr. Balakrishna?
I am ready.
I am not observing. Because observing in matrimonial matters, the lawyer is misunderstood. And he is concerned because he did not argue. Mr. Misra argued. He said that since I am not concerned, but I mean, he's known to the person.
Wait, I have gone through a lordship's order. It's a very lengthy order relying on that Neha's case. But here, not in fact.
The reason being, because why I filed, because now you are reading the bar. I find the subject matter is not at all dealt with any seriousness by the lawyers.
Right.
Everyone is telling a sad story. More chakri nahi, more everything has been dealt with by the Supreme Court. ମୁଁ ଦେଇପାରିବିନି ସେ ଭଲ ଲୋକ ନୁହନ୍ତି ସେ ଘର ଛାଡି ପଳେଇଲେ ଆଉ ଜଣେ କହିଲେ ଯେ ମୁଁ ତାଙ୍କର ଘର ଜୁଆ 14 ବର୍ଷ ଥିଲି
କିନ୍ତୁ এই case she has general manager is drawing 1,70,000 per month and he has not filed that affidavit in view of that Neha's judgment in the trial court. Now in the revision he is raising that question. Can he do that?
He is relying on ex parte decree of divorce.
Yes, but
now divorced wife is also
entitled to maintenance.
125 3 is there.
Yes.
1 no 125 is proviso tax.
Lot of Supreme Court decisions. Honorable Justice Deepak Mishra's judgment very elaborate. She is entitled till she gets married.
That is the concept in the statute also. 25 re seta achi, 125 re se achi. 25 in Hindu Marriage Act. So dekho to jadi I mean there are good reason Mr. Samantra is that because I think he is already married again.
No. He is married. I am not married.
So he is married.
Yes.
So you have to think in those lines because till I mean the case is kept pending. Something will be thinking, the lady will be thinking that something will happen.
No, she is no more because she knows.
Because there will be no, what you call, not exactly improvement. I mean, no future in the relationship.
Question doesn't have, because the ex parte decree was obtained filing in Andhra Pradesh only to get married, Millers. So he has been successful in his effort. Now the person, the lady is suffering, Millers.
In one matter, both of you, I will kindly just take note of this. In 125 matter, it was filed here. They settled for permanent alimony, 8 lakhs, that matter, but not that kind of earning what your client is having. And after they settled, now they will be filing 27 Special Marriage Act is a mutual consent, similar to 13B. I may be wrong. 22 na 27 is a Special Marriage Act. Right? So that is also working out. But here is a case, only 25 is left since you are relying on that decree of granting divorce. So either you can file 25 in the trial court, you can agree here. Possibly 125, but my understanding is that 125, this court doesn't have jurisdiction to take a 25 application.
Right.
MATA is 25, the division bench. But being 227 court, so I am observing that, but simply you can file that 25 if you agree. And take a decree there in 25 so that you will be confident regarding the litigation and the other side will also be confident. It upon 125 range, na?
125.
Dekho, these are the possibilities you can explore. So you use your good offices.
I have already used my good offices.
No, if you have already used, you say what is your client intends to do.
Because the reason is related to, that is the reason I
No, the question is that legal issues have to be answered by the court.
Right.
Why I was telling Mr. Samantra that why I am passing elaborate orders on the first day itself. Because I find no substance in the arguments. If you are denying the maintenance, fair enough. But please rise to the occasion, assist the court so that court can pass an order denying maintenance. No, I am not telling you. So that is the reason I have tried to draw attention of the Lorded Council that these are the provisions now.
That's more possibly because the petitioner in the second case is related to my friend, he can explore the possibility of permanent alimony or every month he will get one lump sum. She agrees, that can be settled.
That I want, that I
Yes.
said that even in one case it has happened.
Right,
But I
I'm
am
also
not
saying
accepting
that.
that. Usually I don't refer 125 because it's a maintenance. Because in the one matter from last Lok Adalat I was sitting, Berhampur, Gauri Amma, she appeared. She was a little bit scared also to speak. Then she spoke that for 13 years it is referred to Lok Adalat and she and her daughter, they are struggling, getting nothing. In the rules of matter to refer to Lok Adalat, the maintenance is not being paid. That is also happening. So, if you can work out both of
Tuesday or Wednesday, I'll take instruction.
no, not wait.
I'll
You see, the persuasive value with a short period is very difficult.
No, it will.
ଆପଣଙ୍କୁ permanent alimony ପାଇଁ, if you are getting an offer, if I've already said, we can tell it now also.
I
you
said
take
I'll
instruction.
finally I'll put in a word and it will be final. It will be final.
The fresh admission କେବେ ଆସିଲେ ହବ ତାହେଲେ? After the before vacation.
Before vacation.
କୁହନ୍ତୁ କେବେ ଆସିଲେ?
And the ପଇସା ବି ମତେ ଆଜି ଦେଇନାହାନ୍ତି।
ନା execution.
Award ହେଲା ପରେ।
Execution or for
Execution file ହେଇଛି, there is no stay, in spite of that no amount has been paid. ତେଣୁ ଯଦି one time
execution ପୂର୍ବରୁ salary attach ହେଇକି ଯେତିକି ଟଙ୍କା ସେତିକି ନେଇ ହବ। But ତା ପୂର୍ବରୁ let us give a chance.
ନାଇଁ I don't say
Because this relationship has no future.
Right.
And she with a hope something may happen, nothing, and now she is educated and she understands that nothing will happen because he has already married.
Because of the fact that they are married, how can she not again expect?
Married and a wife also has recently expired.
Still was. Then it can happen the other way, like in one case in Marwan, they married again. After divorce, they married. Both the council said that they have married, so we thought that it is a married. When the lady has married another person, then the husband has married. No, they have married each other. So, always fact is stranger than fiction. That can happen.
So being personal.
See, the wife died in suspicious or normal circumstances?
No, natural death. She had an heart attack.
Then my friend can use his good office and personal relationship, let him come up with any formula, so I will also explore the same law.
If you are feeling embarrassed.
No, I'm not embarrassed.
Because your client may say that you have not done enough.
No, that's why Tushar is on his legs in another court.
Yeah.
Let it be on 15th. 15th or 18th.
18th week same position fresh admission. Simply. Acha, ठीक अछि Mr. P.B. Balakrishna first matter.
I also request that my friend
also.
I will also try to explore now because
he also explores it.
Mr. P.B. Balakrishna, Mr. P.B. Balakrishna for the petitioner, opposite party, Mr. L. Samantray, senior advocate, along with Mr. Jitendra Samantray. Mr. A. and A. Sahoo for the. Appearance of the learned counsel for the learned counsel for the petitioner and the learned senior counsel for the opposite party were heard at some length. So the context was future of the relationship between the parties, as the petitioner herein has obtained a decree of divorce and has married again. Obtained a decree of divorce, ex parte. From the court at Nellore. From the judge, from the family, from the court of learned judge family court Nellore, Andhra Pradesh, by judgment dated 21/12/2010. Earlier, the matter was heard at length and detailed. Had at length on PC the contentions and submissions of the learned counsel for the petitioner were noted. The case law was also discussed. Stop. The learned counsel for the parties are requested to use their good offices to explore the possibility of amicable settlement between the parties regarding future of the marriage, maintenance for the permanent alimony, that would be acceptable to both. So, the matter shall be listed under the same heading, listed for fresh admission in the week commencing 18.
Great.
ଆପଣ 18 ୱିକରେ ବୁଝ ରହୁନାହାନ୍ତି ସେମିତି କିଛି ନାହିଁ ତ
ନା ସାର୍
ଆପଣଙ୍କର ଯାଉନାହାନ୍ତି ଠିକ
ଯାଇ ହବନି ସାର୍ 20ରେ ଦହି ପଖାଳ 22ରେ
ଆପଣ 20ରେ ଠିକ ଅଛି ଆପଣ ବୋଧେ ସେଥିରେ ଇନଭଲ୍ଭ ସେଇଥିରେ 20 ଦିନ 22 ଦିନ ରହିବେନି ଆଉ
ଗୋଟେ ବର୍ଷ ଯାଏ ଆଉ ଛୁଟି ନାହିଁ
yes
Second.
ଆଜ୍ଞା
Second.
second matter
Second,
Mr. Nalatendu Samantraya, senior advocate, along with Mr. J. Samantraya and A. Sahoo for the petitioner, Mr. Second वकालत नामा फाइल करना है
फाइल करो नेक्स्ट टाइम पर
okay blank Mr. P.V. Balakrishna, learned counsel, submits that he has instructions to appear for the opposite party. So the matter is listed along with the connected RPFM 118/2025 stuff. In view of the order passed in the said RPFM, the matter shall be listed together in the week commencing 18/5/2026.
Item 5.
It reads for a short password, my lords. Mr. Panda is just on his legs. He's coming from
Password?
court. Repeat.
Yes. 6.
Item 6.
Ms. Jyotsna Rani Ratha for the petitioner, Mr. Prem Kumar Mahar.
already compliance petition has been filed, my lord.
Compliance appeal. Madam Ratha, you have received copy.
I'm sorry.
Madam Ratha, will be today you will deal with it or you want time?
My lord,
ଆଜି କରିବେ ନା ଟାଇମ ନେବେ କପି ନେଇକି ଦେଖିବେ
already I have information that the opinion note has rejected the prayer of the petitioner.
complied with ଆପଣ ତ ଚ୍ୟାଲେଞ୍ଜ କରିବେ
Yes, my lord.
correct that's a good approach legally sound approach Prem Kumar Mahar लिखिले the learned additional standing counsel refers to the compliance affidavit filed by the OP number 2 same not K by the OP number 1 alleged contempt of stuff. He submits that the order dated order dated 30/9/2024 passed in WPC passed by the coordinate bench in WPC
22734.
passed by this bench in WPC number 22734 of 2024. Has been complied with. The opposite party has delay na timely ହେଇଛି as expeditiously as possible for like yes has been complied with stop paragraph 3 of the affidavit compliance affidavit dated 2/5/2026 is reproduced here. The copy of the affidavit has been served on the learned counsel for the petitioner. It is submitted by the learned counsel for the petitioner. The petitioner shall have the liberty. The petitioner, the claim of the petitioner, admitted that the claim of the petitioner has been rejected, and petitioner shall seek redressal of grievances by appropriate legal through appropriate legal remedy. The petition starts dismissed. The content petition is dropped. Yes.
Item 7.
My lords, I am for the wives. One.
पास ओवर कले वेट करि परिबे नाहंती पास ओवर करा जाऊ or you have any other matter anyway आपण रही अपेक्षा करि परिबे त yes please wait pass over
Page 9.
passed over
Item 9.
Mr. H.K. Mahanto for the petitioner. Yes,
Your Lordship, present petitioner is the wife seeking for transfer of mat case from civil judge senior division Nilgiri to Baripada, Your Lordship. I think the husband filed under section 13
okay.
of Hindu Marriage Act. But here at Baripada, I have filed under section 9 of Hindu Marriage Act.
Restoration. आपण
My
अपील
lord.
कले restoration.
My lord.
ते पाख जगह एकाठी आपण एका जगह केस करिया चाहूँ एकाठी रहू ना
से नौनाहांती
सेपट लोक आपण नीलगिरी बारिपदा कम बाट जानते
again. At Baripada, my 2 cases pending, another 125 CRPC also pending.
take notice had learned counsel for the petitioner. The petitioner wife in the marriage seeks transfer of the CP number 177.
That is made case, Your Lordship.
आपण नीलगिरी बारिपदा चाहूँ
Again.
अच्छा
Made case 34 of 25.
six transfer of the CP number 34 of 2026
2025.
to हमर भूले गए कौन है यार यूजर चौक Mat case number 34 of 2025 pending before the learned senior civil judge Nilagiri, Balasur, to the court of learned judge family court to the court of learned family judge Baripada at Marwan. The mat case 34 of 2025 has been filed by the husband in the marriage under section 13 into bracket capital A of the Hindu Marriage Act, seeking dissolution of the marriage solemnized between the parties on 16/2/2021, as well as for grant of decree of divorce. For nobody, as well as grant of decree of divorce. Stop. It is submitted that CP number 177 of 2025 filed by the wife under section 9 of Hindu Marriage Act is pending before the learned judge family court Baripada at Mayurvanj. She has sought for monthly maintenance under section 125 of CRPC, which is pending as CRP number 212 of 2024 at or before the judge family court Baripada at Mayurvanj. So, it is submitted that in the interest of justice, all the matters should be tried together. The petitioner finds it difficult to attend the matter at Nilagiri. No. Para. Issue notice along with this order to the opposite, issue notice to the opposite party along with this order. Para. Requisites for issuance of notice by speed post with registration and proof of delivery. We filed within 5 days, within 5 working days. Returnable date be fixed to 30/6/2024. The matter shall be listed in the week commencing 6/7/2024. Stop. IA 151 of 2026. Issue notices above. Accept one set of process fee as well as postal requisites along with the petition. In the interim, it is directed that further proceeding in CP number 80 before mat case number 34 of 2025 pending before learned
civil judge,
Senior Civil Judge Nilagiri, comma. CP number 177 of 2025 pending before the Learned Judge Family Court pari for that shall be adjourned to a date beyond that listing date kebe कहले
we continue 6-7.
well date beyond 13/7/2026 as would be convenient to the Learned Courts in season of the matter. इतने add कर देवे गोटे सपोज the returnable date and the next date of listing shall be as directed above. आपण फाइलिंग सर भूले हमर भूले देखो this opening sentence लिखंतु it is submitted by the learned counsel for the TRPC रे कोन TRPC तो भूल नहीं केस नंबर टा अनेक्सर देखिले आपनकर अनेक्सर 3 टा देखिले 26 ही जाईची सीपी 34 ऑफ 2026 जो जोटा कि आपनकर एक्चुअली 25 किंतु कोर्ट मास्टर कहउछन जे सेटा एक्चुअली ब्रीफ रे ही 26 ही जाईची देखिबे रे देखि इंडेक्स देखिले इंडेक्स देखिले सेमाने जेतले बुक मार्किंग एक्चुअली हमर बुक मार्किंग होची इंडेक्स ता से बुक मार्किंग कला सेटा टाइप कर दी is submitted by the learned counsel for the petitioner that advertent typographical error has crept into the just a bhitori भी कोन भूली
नहीं भीतर नहीं
check करू advertent typographical error has crept into the index page of the petition wherein the annexure 3 has been mentioned as CP number 34 of 2026 instead of CP number 34 of
मैट केस नंबर 34
अच्छा सेटा भी भूली जाईची अब से पे मोर बारंबार भूलु
इंडेक्स
आपण मते तीन थरा कहले बट मु लक्ष्य करनी जे has been mentioned as CP number 34 of 2026 instead of MAT case number 34 of 2025 है तो he seeks leave to correct the cause title by carrying out the necessary correction in pen stop leave granted the learned counsel shall carry out the necessary correction which shall bear his initials to be countersigned by the court master कर दियो तो देख से कर दे भीतर भी चेक कर दियो
Item 11,
पासवर्ड डाकी दियो ठीक है
password item 5. Item 5, my instructions are,
yes please
but if your lordship will grant some time, we will arrange and deposit the entire.
okay Mr. Devasis Ponda for the petitioner along with Dhirendra Kumar Mahapatra for the petitioner the learned counsel refers to the earlier order
Dated 17/4.
17/4 dated 17/4/2026 ता पूर्वरी गोटे ऑर्डर थिला होते डिपोजिट
ता पूर्वରୁ ଗୋଟେ କେମିତି ଆମେ
11/2
how we will comply ସେଟା ହେଉଛି 15/4
ना 11/2 हाँ 11/2
ହଁ 11
the order dated 11/2/2026 and the and 17/4/2026 and submits that he may be granted for the time the petitioner may be granted for the time to enable him to provide instruction. Stop. Accordingly, the matter shall be listed in the week commencing after vacation. Week commencing 29/6/2026. The learned counsel submits that the interim or direction as in order dated 17/4/2026 may be extended. Stop. The stop. Para. The said para accordingly directed that the execution case number
that is the execution cases
number ta पढ़िया कथा पढ़िए or arising out of execution case arising out of इत्ते case number ta okay ना judgment dated 17/6/25 in CRP number 304 of 2019 shall be adjourned. Upon kete date dele 29/6 shall be adjourned beyond 6/7/2026 as would be convenient to the learned court in season of the matter. Madam, your matter.
Item 7. The execution case number is 150 of 23.
50 of 20 EXP
158.
नहीं cost rate कौन है?
Criminal execution number.
ERL EX.
CRL dot EXP dot. Everything out of figures.
I 158 of 20.
158 of
25.
2025.
I am, item 7.
She accommodated. She said that I will.
I'm extending. Sorry.
Madam, you want to say something?
Also state a continuum, then copy to
Copy the sorry.
Copy something.
No.
I have
Last
already
matter लिखिए Mr. Shalajanandan Das for the petitioner. आपन power file करना है कि?
I have for the Wi-Fi.
हाँ power नहीं विश्वमोहिनी पात्र power किसी नहीं blank अच्छी.
How can I see?
जी.
हाँ, DP देना, दुर्गा प्रसाद देना, ऐसा हो?
and जो tier you will try.
ये ले ऐसे ही.
नहीं, if it is not there, you can file it, but it has to be recorded correctly. Most likely नहीं madam. कहना गोटे मुकलत नाम देखुच. That is of Shalajanandan Das. File करों तू है ला?
हाँ.
आपन को ना?
State a continuum होने.
आपन को ना madam?
Yes, Sahoo.
सुमित कुमार जो TRP CRL TRP CRL 29 of 2026. Shalajanandan Das for the petitioner, opposite party blank. It is submitted by the Lorded Counsel, A. Sahoo. S. Sahoo.
Yes, ma'am.
Again, S.
Yes,
Sahoo.
Sahoo, Sukant.
Miss Sukanti Sahoo, Ms. Sukanti Sahoo, that she has instructions to appear on behalf of the opposite party. She may be served with a copy of the application. अपन कितने दिन नेबे ओकले तमा पे? 7 दिन. Na 2 weeks.
2 weeks.
She submits that the wakalatnama, duly executed wakalatnama by the opposite party shall be filed within 2 weeks. Stop. Upon filing of the wakalatnama, the same shall be taken on record, scanned copy be updated. Name of Ms. Sahoo along with learned associates shall be mentioned in the cost list as well as case brief. It is submitted by the learned counsel for the petitioner that he is serving copy of the application in the court today. Yes, the court today. इतने कौन interim order अच्छी?
order पे 21/4/26.
When this maintenance है ये driver stay driver तक से maintenance 5 करना तो this very poor lady. It is
instruction देखो अपना कौन जदी instruction नियम तो तक maintenance ना पे usually maintenance should not be stayed. That is the mandate of law. Actually, the stay है नहीं खाली adjournment order है जी. I am not passing stay order. Very rarely I am passing. So you, I mean, my point is that as a law, I mean, you have the legal recourse to get maintenance, to make a prayer before the court. Court may pass order. They may take some steps. But अपन जो जिसने बॉसी की रोहे पे अपेक्षा करी वजह से ऐसी की देबे सेटा हबनी. Even yesterday it was argued because it is not executed, I am not paying maintenance. The most strange interpretation of a decree of a court. The court issued on NBW. Out of 3,190,000 has been paid, 1,90,000 has been paid. So to that extent, the matters are being staged. There has to be execution, there has to be a distress warrant, there has to be some kind of further coercive order. Then only they are saying only thing. Sorry, serving copy. The learned counsel for the opposite party submits that either upon a paunanti. Case study.
CP.
Stay food achi food.
Stay down to CP. CP होची
ନାଇଁ ମ୍ୟାଡାମ ସେଟା ପଚାରୁନି TRP 29 ନା 1 ରେ କୋଉଥିରେ ଷ୍ଟେ ଅଛି?
ଏ ତାଙ୍କ କେସ୍ ହେଇଛି
ତାଙ୍କ କେସରେ ଷ୍ଟେ କରୁଛନ୍ତି
ସିଏ ମାନେ ଆମେ ଯୋଉଟା ଫାଇଲ କରୁଛୁ ଫର ସେକ୍ସନ 9 ଟା ଇନ ଭୁବନେଶ୍ୱର କୋର୍ଟ ଦ୍ୟାଟ୍ ହାଜ ବିନ୍ ଷ୍ଟେଡ୍
ଷ୍ଟେଟା କଣ୍ଟିନ୍ୟୁ
ଆପଣ 24 ନା 125 ରେ ପାଉଛନ୍ତି କୋଉଥିରେ ପାଉଛନ୍ତି ମେଣ୍ଟେନାନ୍ସ?
ମେଣ୍ଟେନାନ୍ସ କିଛି ପାଇନୁ 25
କେସଟା ଫାଇଲ ହେଇଛି
ଫାଇଲ ହେଇଛି
25 ଟା
ଫାଇଲ କରିଛନ୍ତି ତାହେଲେ କେମିତି ହବ?
ସେଇଟା
How can I direct when the case is filed there? You have to take steps. I thought it had a 125 challenge ହେଇଛି because of interference ସେଟା stay ହେଇଛି
ଆଜ୍ଞା ଷ୍ଟେଟା କଣ୍ଟିନ୍ୟୁ
ଠିକ ଅଛି କଣ ଲେଖିଲେ ତାପରେ ଲେଖନ୍ତୁ the learned counsel for the petitioner refers to the order dictated 21/4/2026 and submits that interim direction may be continued. Accordingly, it is directed. What is the date question?
No, sir, date.
Accordingly, it is directed the CRP number 95 of 2025 pending before the Lord Judge Family Court Kendrapada shall be adjourned to a date beyond କୋଉ ୱିକରେ ଆଣୁଛନ୍ତି ଆପଣ? 13 beyond 20/7/2026 a matter shall be listed under the same heading on 13/7/2026. Second matter ରେ ଲେଖନ୍ତୁ MS Sahoo for the petitioner, Mr. Shalajanandan Das for the opposite party. ଆପଣ matter ରେ ଆପଣ stay ନେଇଛନ୍ତି that Mr. Das is saying. Plus TRPC 1/2026. In view of the order passed in the connected application listed today, TRPCRL 29/2026, the matter shall be listed in the week listed together with the said matter in the week commencing 13/7/2026. Sorry, 6/7 कहले ना? 13/7/2026 ହେଲା for fresh admission. Stop. The CP number 458 of 2025 pending before the Learned Judge Family Court Bhubaneswar shall be adjourned beyond 20/7/2026 as would be convenient to the Learned Judge Learned Court in season of the matter. Yes. ଆପଣ ଇନଷ୍ଟ୍ରକ୍ସନ ନିଅନ୍ତୁ କିଛି ଯଦି ଆମାଉଣ୍ଟ ଦେବେ
ଫାଇଲ ଖାଲି ହେଇଛି
ମୁଁ ବୁଝୁଛି ଯେ ବର୍ତ୍ତମାନ କଣ ହବ ନା ସେଠି ପ୍ରୋସିଡିଂ ହବନି ଏଠି ମ୍ୟାଟର ଆଡଜର୍ନ ହବ ସୋ I understand. I got your point. In fact, initially you clarified that. I understand that. But still ଆପଣ ପଚାରନ୍ତୁ ଆପଣ ନ ପଚାରିଲେ ସେ ଶୁଣିବେନି କିଛି. Yes. Yes.
Item 11.
The Prakash Kumar Mishra for the petitioner.
May I please your order?
Mr. Prem Kumar Mahanti for the opposite party.
My lord, the petitioner prayed for a direction to the opposite party number 4 to issue NOC in favor of the petitioner, my lord. The case
NOC
is that,
co-provision, sir, co-provision.
my lord,
NOC is a legal right हवा दरकार.
my lord, yes, lordship.
Co-provision.
The present petitioner has availed loan from Odisha Khadi board, my lord. She has not deposited the loan for
But
that reason.
ନା ତ ମୋର determination ନାହିଁ
Again.
ଅଛି ଲୋନ୍ ଫୋନ୍ ତ ମୁଁ
ସେ OPDR ଦେଖେଇଛନ୍ତି ବା SR ଦେଖେଇଛନ୍ତି OPDR act. What happened, your lordship?
against କଣ OPDR
ଆଜ୍ଞା
ଓ ଚାଲିଛି
ଆଜ୍ଞା. I have failed to repay the loan. For that reason, a certificate proceeding was initiated against me. I have deposited all the certificate amount since 2025, your lordship, 7/27/2025.
instruction ନିଅନ୍ତୁ.
Yes.
It's a case of I mean sir
If your lordship,
satisfying the certificate.
if your lordship pleases to peruse Annexure 5 at page 22, they have stated already. I have given the
But ଆପଣ section 8 ରେ application ରେ ଏଟା ଦବା କଥା ନା
section 8
problem ହଉଛି ଯେ ଆପଣ ସେଠି ହେଲା certificate case
ଆଜ୍ଞା
ଏଠି ହେଲା 226. I don't have certificate jurisdiction. He doesn't have 226 jurisdiction.
ଆଜ୍ଞା
ଆପଣ ସେଠି section order 8 OPDR ହେଲେ ସେଟା ହବ section ବୋଧେ section 8 you have to file that application denying the liability.
ନାଇଁ ଆଉ ମୁଁ ପେମେଣ୍ଟ କରିଦେଲି ପୁରା
ତାହେଲେ ଆପଣ ଡିନାଇ କରିବେନି କିଏ କରିବ
ନା ପୁରା
ପେମେଣ୍ଟ କରିବେ
ପୁରା ପେମେଣ୍ଟ କରିଦେଲି
ଆପଣ ଯୋଉ ପୁରା ପେମେଣ୍ଟ କରିଦେଲେ ଆସିକି ଏଠି 226 ରେ କହୁଛନ୍ତି ସେଠି ସାର୍ଟିଫିକେଟ ରେ କହିବେନି
certificate proceeding has been closed.
ତାପରେ ତାହେଲେ ଆସିଲେ କାହିଁକି ତାହେଲେ?
Certificate proceeding has been closed by the certificate officer sub collector Bhubaneswar. ସିଏ ଆଜ୍ଞା ଖଦି ବୋର୍ଡକୁ ପଇସା ଦଉନାହାନ୍ତି ବୋଲି ମତେ ଖଦି ବୋର୍ଡ ଏନଓସି ଦଉନି।
ସିଏ ମାନେ ସିଏ ହେଲେ କିଏ?
ସବ୍ କଲେକ୍ଟର ଦ ସାର୍ଟିଫିକେଟ ଅଫିସର।
ସିଏ କଣ ପଇସା ରଖନ୍ତି?
ସାର୍ଟିଫିକେଟ ଅଫିସର ଆଜ୍ଞା ସେ ଇଫ ୟୁ ଲର୍ଡସିପ peruse one line
ସିଏ କେମିତି ପଇସା ନେଇଗଲେ?
ସେ ସାର୍ଟିଫିକେଟ
ପ୍ରୋସିଡିଂ ରେ ଆପଣଙ୍କର ଯିଏ
your lordship may peruse page 29 19
it is between certificate holder and the certificate debtor. ଆପଣ କହିଲେଣି ଯେ ସାର୍ଟିଫିକେଟ ଅଫିସର ନେଇଗଲେଣି ପଇସା।
ଆଜ୍ଞା ଦେଖୁନାହାନ୍ତି ପେଜ 19 ପେଜ 19 ର ମୁଁ ଦେଖୁଛି ଅର୍ଡର ସିଟ୍ ଟା case record is put up today the city is present and deposited the certificate dues amount of rupees 30,37,446 as mentioned in my order dated 22
ଆପଣଙ୍କର ମାନେ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ୟୁଜ ହିସାବରେ ଗଲା ଭରି
ଆଜ୍ଞା ଦେଇଦେଲି ହଁ ସେଥିରେ ଡାଇରେକ୍ସନ ଦେଲେ ଲାଷ୍ଟ ପାରା ଦ ସେକ୍ରେଟାରୀ ଓଡ଼ିଶା ଖଦି ଆଣ୍ଡ ଭିଲେଜ ଇଣ୍ଡଷ୍ଟ୍ରି ବୋର୍ଡ ଓଡ଼ିଶା Bhubaneswar is requested to come and send a representative with authorization to receive the amount of rupees 30,37,000 except cost of process fee of 20 on proper receipt acknowledgement from the Nazir of this office put up draft accordingly. Next order, your lordship.
Do you have any idea whether it has been received by the certificate holder?
No, no, that has not been because Annexure 5 says Annexure 5 says
Annexure 5 is something else. Annexure 5 you are extrapolating that data. ଆପଣଙ୍କର ଅର୍ଡର ହେଲା କେବେ?
10/3/2025 ରେ
10/3/2025 10/3/2025 ରେ ସବ୍ କଲେକ୍ଟର ପାଖରେ ରିସିଭ କଲେ କି ନାହିଁ ସେଇ ଜିନିଷଟା ଆପଣ କେମିତି ଜାଣିବେ?
ଲେଖା ହେଇଛି ପୁରା ଅର୍ଡର ସିଟ୍ ରେ
ପଢୁନାହାନ୍ତି
ଆଜ୍ଞା
then you will understand what I am saying.
ଆଜ୍ଞା
then you will understand what I am telling you. ଆପଣ ପଢନ୍ତୁ ଯେ ସେଇଟା
ଆଜ୍ଞା if you lordship peruse page 18 annexure 2 it is order dated 10/3/2025 of the certificate officer the case record is put up today on perusal of
ସେଟା ମୁଁ ପଚାରୁଛି
ଆଜ୍ଞା
ଆପଣଙ୍କର ଯୋଉ ଡିପୋଜିଟ୍ କରିଦେଲେ ଡିପୋଜିଟ୍ କଲା ପରେ ସାର୍ଟିଫିକେଟ ହୋଲ୍ଡର ପଇସା ନେଲେ କି ନାହିଁ
ନା ସେଟା annexure 5 କହୁଛି ବା ସେମାନେ ମାଗୁଛନ୍ତି annexure 5 letter issued by the secretary khadi board to sub collector
କି ଇସ୍ୟୁ କରୁଛନ୍ତି କାହିଁ ଏତେ ଇମ୍ପୋର୍ଟାନ୍ସ ଦଉଛନ୍ତି
ଆଜ୍ଞା
କଣ୍ଟେକ୍ସ ପଢନ୍ତୁ
to the certificate debtor subject to the deposit of realized amount in the certificate process case number 105 of 2001
reference ଦେଖନ୍ତୁ
ଆଜ୍ଞା reference your letter number 265 dated 13/3/2025
important 13/3/10/3/25
ଆଜ୍ଞା
सर्टिफिकेट रे केस रे को दिन ऑर्डर हैला
10/3/2025
so naturally
thereafter on order dated 13/3/2025 the certificate of
होंतुनी सर
आगे
you are missing the sequence आपनकर सर्टिफिकेट रे जो दिन आपण डिपॉजिट करले ऑर्डर हैला आपण को
आगे
से दिन आपण डिपॉजिट करले की
आगे
कले ऑर्डर हे गला
आगे
सेम डेट रे आपण गोटे इश्यू लेटर इश्यू करछन तांकू
आगे सब सर्टिफिकेट ऑफिसर करले
आपण आउथरे से ऑर्डर टा चेक करले वेरीफाई करले
आगे 13/3
जो तरी सर्टिफिकेट ऑफिसर कहिले जे डिपॉजिट हेछि बोली
आगे 13/3 पेज 19
हां
13/3
तो 10/3 रे डेफिनेटली नॉट डिपॉजिटेड
10/3 रे certificate of officer has not given to certificate
so that I wanted to point
out
that whether you infer that from this order because they are referring to 10/3
again
now read
10/3 and 13/3
just read
10/3 रो
अरे annexure 5 रे अपन अटकी
आगे sorry my lord हां your letter reference
to the letters
again inviting your reference to the letter and subject certificate I am to intimate that one Srimati Ratnapal Mahapatra Loni was available loan under CBC scheme and stated that she has already paid an amount of 30,37,460
reference to the letters
in the office of sub-collector cum certificate officer Bhubaneswar on dated 27/2/2025. This office has been intimated the bank details to remit same to Odisha Khadi and Village Industry Board, but till date the same has not been deposited in board account. Therefore, I once again the bank account details of the board is given below and request you to kindly deposit the deposit.
Zero nasti zero pida. What is going on? से डिपोजिट कले कहले आपण नियंतु आपण कहले आपण दियंतु व्हाट इज दिस गोइंग ऑन
And I am suffering a lot.
I'll take instruction.
इंस्ट्रक्शन करने बेटा क्लोज करंतु नहले आई विल इंपोज हेवी कॉस्ट both of this the secretary Odisha Khadi village because these are golden opportunities when you wait to punish somebody you do not get opportunity this completely complete non-application of mind or lack of complete intelligence
And
what is
my
IQ test habo apna moron to be come habo apna what is going on
more than a year, my money is with them.
Director Patna 2-3 they have separate panel of advocate.
अरे पैनल जानतो आपण तांकर ये करंतु नहले तांका अवस्था खराब करंतु you should pounce upon them these are not the cases to be adjudicated before the high court it's complete wastage of time complete wastage of time ଏବେ ନୋଟିସ ଇସ୍ୟୁ କରିବାକୁ ପଡିବ ଆଜି ୟୁ ହାଭ୍ ଷ୍ଟେଟ୍ କଣ କୁହନ୍ତି ସୋ ଆହୁରି ଗୋଟେ 2 ମାସ ଯିବ ଏଥିରେ ସୋ ପିକେ ମହାନ୍ତି ପିକେ ମିଶ୍ର ପିକେ ମହାନ୍ତି ନା ପିକେ ମହାନ୍ତି ଏସି ଫର ଓପି ନମ୍ବର 1 5 6 7 the Hard Lawyer Counsel for the petitioner refers to the order passed by the certificate officer. Page ta kohuntu. Comes from collector Bhubaneswar.
Page 19.
Dated 13/3/2025. Case number ta kichi padichi. In certificate case number 105 of 2001. The said order is reproduced here. Stop. They submitted that thereafter, even after satisfying the loan demand by deposit of the entire amount, the petitioner who was the loanee is not being issued a no objection certificate. Purportedly on the ground that the amount has not been received by the Odisha Khadi and Village Industries Board. Personal appearance kariye Mr. Mahanti. You should say that they should appear personally and explain you first, then if required to the court.
They are government departments, my lord. They are
Whatever, what is this? They are having fun here.
2, 3, 4 are government departments. The notices to go on.
Received by the Odisha Khadi Village and Industries Board stuff. He then refers to the order dated on the office letter dated 7/2/2026 issued by the Secretary Odisha Khadi and Village Industries Board, Hon'Ble Nagar, Unit Roman 3, Bhubaneswar, which discloses the following, which indicates the which contains the following. What is scan kori bhi reproduce kar do kari. Give the letter. Stop. It is apparent from the perusal of the annexure 5 and annexure 3 referred above.
3 series.
That the amount due has duly been deposited. The loan has been discharged. The certificate has been discharged. Closed. Stop. Issue notice along with this order to the opposite parties 2, 3, and 4 by speed post registration proof of delivery. Stop. Indicating that the matter is to be disposed of at the stage of admission. Pendency of this petition shall not be of any impediment for the opposite parties. Opposite party number 2 and 6. 2, 4 and 6 to sort out the issue, in as much as OP number 6 has already written, having receipt, having already written, having the amount being already deposited. The amount has already been deposited. OP number 2 and 4 have also admitted that the amount has been deposited, but the issue, the probable issue seems to be how the amount will be transferred from the account of OP number, opposite parties number 6 and 7 to the account of opposite party number 2, 3 and 4. So, in any event, the petitioner can no way be held responsible for the interdepartmental transactions between the opposite parties. Do we say what thing? 6, 7, between party 6 and 7, and 6 and 7 on one hand, and 2, 3 and 4 on the other. Yes.
Well, I'll take instruction for 6 and 7, man.
ଯାହାଠୁ ନେବେ ନେବେ ସେଇଟା ତ ଆପଣଙ୍କ ପାଇଁ ନୋଟିସ ତ ଯାଉଛି, ଆପଣ ତ ମନା କରୁଛନ୍ତି ଆଉ।
No, I'll take instruction.
The requisites for issuance of notice to OP number 2, 3 and 4 shall be filed within 5 working days. List for orders in the week commencing 29. Yes. Yes, please.
Obliged.
Item 12.
May I please, Lord, I am on BC Milord.
Yes.
Milord, the petitioner are the maternal grandparents, Milord, challenging the order passed by the Lorraine family judge in IA number 12 of 2025 arising out of guardian petition number 2025. Milord, the opposite party number 1, who is the son-in-law of the petitioner, Milord.
Contact and vegetation right.
Yes, Milord.
You are opposing contact and vegetation right?
No, Milord. I am not opposing the Milord.
What is the page of the impugned order?
70, Milord. Kindly come to the page number 70 is 71, Milord. 70, running page 70.
Yes.
Order person. The IA filed by the petitioner is dismissed on contest. But at the same time, the opposite party number 1 is directed, if the petitioner visited to his house to see the minor child, he shall cooperate with them and shall not raise any objection during their meet with the said minor child.
You are agreed by this order?
Milord,
vegetation and contact rate कहले मना कहीं करछन?
Opposite party number 1 जे कि हमर जोई ता नारे मर्डर केस चलची जे कि मो झियो को मार देइची.
एटा कोर्ट रे आपण एटा पढिछन त लॉ हैव यू चेक द लॉ ना भाषण दउछंती?
No, Milord, I am citing
the fatherhood of a child will be denied to a murder accused. एटा कोर्ट handle आपण.
I am not saying so, Milord.
That is the court of law, sir. What we are discussing now.
Milord, Annexer 3. Kindly have a glance to Annexer 3, Milord.
Apart from, you should be kind to the law also.
Milord.
So, upon the proposition that कहले, can I pass a order since he is accused? He loses his, natural guardian, being he ceases to be natural guardian of.
Opposite.
Have you read Peri Consagra versus Smriti Badan Consagra?
Opposite party number 1 जे Milord custody रे थिला.
Opposite party number 1 कोटी से Peri Consagra रे आसला.
Milord, opposite party number 1.
You want to deny the contact and vegetation right of the.
I am fearing to.
Are you denying the parenthood of the accused?
No, Milord, it is not this.
Then how can you?
CWC.
Prepare seriously instead of making a speech. This is not a place for making speeches.
No, Milord, I am submitting.
And you must understand this is an accusatorial proceeding. He is presumed to be innocent.
Milord, yes. मते CWC handed over करथिले पिला को मु ताको रखितिली जेतबेले मु
ପିଲାକୁ hand over କଲେ ଆପଣ ପାଇବେନି ବୋଲି how can I if you have a legal proposition don't make a speech sir I am requesting you. You have to be kind towards law apart from being the court kind towards the petitioner or the opposite party. ଆପଣ ଯୋଉଟା କହୁଛନ୍ତି it should be legally nuanced.
No, Milord, I am admitting, Milord.
Then it is not going to leave it there, sir. Get adjournment because I can't waste time like this. Apanଙ୍କର first proposition is outlandish. That since he is accused, he loses his right to contact his child. Even the accused persons, ladies staying in jail, they are having their kids with them.
Milord, yes. Milord,
The law is that you should not keep the child in an environment like jail, but still they are having the natural right to have the child.
Milord, ପିଲାଟାକୁ ମୁଁ ଆଣିକି ରଖିଥିଲି ଯେତେବେଳେ ସେ ଅପୋଜିଟ ପାର୍ଟି
ଆପଣ ଯାହା ବି କହୁଛନ୍ତି ମୁଁ ଓଡିଆ ବହୁତ ଭଲ ବୁଝିପାରେ ବଟ୍ ଆପଣ ଯାହା କହୁଛନ୍ତି ଆଇନ ତ କୁହନ୍ତୁ ଆପଣ ପିଲାକୁ ରଖିଥିଲେ ବାପାର ଅଧିକାର ନାହିଁ ସେଇଟା ଆପଣ ଆର୍ଗ୍ୟୁ କରୁଛନ୍ତି ନା ଡୋଣ୍ଟ ମେକ୍ ଇମୋସନାଲ ସ୍ପିଚ୍ ହିୟର ସାର୍ ଆପଣଙ୍କୁ ଯିଏ ଯାହା ଅସୁବିଧା କହୁଛନ୍ତି ଶୁଣେଇଲେ ୟୁ ଗିଭ୍ ଇଟ୍ ଏ ଲିଗାଲ କନୋଟେସନ ଆଣ୍ଡ ଲିଗାଲ କଣ୍ଟୁର ଦେନ୍ ୟୁ ମେକ୍ ଏ ସବମିଶନ
ବାପା ଜେଲରୁ ଆସିଲା ପରେ
ଆପଣଙ୍କର ଯଦି ଆପଣ ଚାହୁଁଛନ୍ତି ଟୁଡେ ଆଇ କ୍ୟାନ୍ ରିଜେକ୍ଟ ୟୁର କଣ୍ଟେନସନ ଅଲସୋ ଆଇ ହାଭ୍ ନୋ ଡିଫିକଲ୍ଟି
short adjournment.
In Peri Consagra, the person was a murder accused in Nigeria or Kenya. Still, he was granted because it's a natural right. You see, any accused person does not lose his right of over his progeny.
Milord, seeking time to verify that.
कौन verify करिवे? कौन verify करिवे आगे अपन तो गोटे जहाँ आसी कि client अपन कहले सीधा आसी कोर्ट रे कहबे. This habit, you please leave this habit.
Sorry.
We are now being watched, sir. Upon sorry, sir, this is not a personal acquisition, or I have not found anything wrong with you. But I am not really. I am really struggling with this. Suppose I am very impressed. Upon the both emotional speech, tell movie lekhi devi taku. The person is a murder accused, and he is accused of killing the mother of the child, so he is denied contact and visitation right. You see, you should be happy that you are having the custody. And this is not the first case. Not the first case. There are several cases, in fact, decided by division bench of this court also. In that Calcutta case, the child was recovered, and he was in a very bad shape. The husband is Supreme Court decision again. But there also, you are not. The court has not granted custody. Mr. अरे नारायण बाबू आपण आसिबे the petitioner कौन maternal grandfather
is maternal grandfather.
The petitioner in the writ petition is the maternal grandfather of a minor child aged about
Yes, 3 years, Milord. High Court, 3 years.
He is before this court being agreed by the order passed by the learned judge family court Jagatsinghpur dated 2/2/2024. In IA number 12/2025 arising out of G.P. number 2/2025. The said GP number 2/2025 has been filed by the petitioner herein, the maternal grandfather of the minor child, against the father of the child and the Child Welfare Committee as the opposite parties. The petition is under Section 12 of the Guardianship and Guardians and Wards Act. Guardianship Guardians and Wards Act. ଆପଣ ଏଟା ସବୁଠି ଗାର୍ଡିଆନସିପ୍ କଣ ହେଇଗଲାଣି ଏଠି ଗାର୍ଡିଆନ୍ସ ଆଣ୍ଡ ୱାର୍ଡସ୍ ଆକ୍ଟ 1890 1890
Guardianship.
ଏ ଗାର୍ଡିଆନସିପ୍ ପିଟିସନ ଟା ପେଣ୍ଡିଂ ଅଛି
ଆଜ୍ଞା petition pending ଅଛି.
the said petition guardianship petition is pending. The interim order passed in the IA is reproduced hearing. Stop. Fine. To challenge the state order, it is submitted by the learned counsel for the petitioner that the father of the child is accused in so and so case number.
Balikuda PS case
In Balikuda PS case number 427
of 2000.
under section देखिए लिखिए भूलभाल करिवेनी section page 66 रे अछि. She submitted that the vegetation and contact right could not have been granted to the father. Stop. The learned counsel for the petitioner is apprised of the fact, the law, that vegetation of contact right cannot be denied to the father of a child merely because he is accused in some case. This section has adjournment list in the week commencing 13/7/2026. You should be patient with the case. Apana seti ko decision hoji seti apekha karibe kon ho dekha. You have to wait. You are also, jumping much ahead of the line actually.
ପିଲାଟା ଏବେ ନେଇଯାଇଛନ୍ତି ସେ
ପିଲାଟା କିଏ ନେଇଗଲାଣି ଆପଣଙ୍କର? ପିଲାଟା ତ ଆପଣଙ୍କ ପାଖରେ ଅଛି.
ପିଲା ମୋ ପାଖରେ ନାହିଁ ଯୋଉ କେସ୍ ଚାଲିଥିଲା ବେଳେ ସିଡବ୍ଲ୍ୟୁସି ନେଇକି ମୋ ପାଖରୁ ପିଲାକୁ ତାଙ୍କ ବାପାଙ୍କୁ ଦେଇଦେଲା ଅପୋଜିଟ୍ ପାର୍ଟି ନମ୍ବର 1 କୁ ଦେଇଦେଲା.
ଦେଇଛନ୍ତି ନ୍ୟାଚୁରାଲ ଗାର୍ଡିଆନକୁ ଦେବେ ଆଜ୍ଞା.
ହଁ
The law is very strict on this. You can't deprive the parenthood of any child also. If you compare the rights also, your right to have the custody of the grandchild and the child's right to have the company of the father. He may be a murder accused. Little bit complicated. तापरे आपन पाखरे रहिले गोटे असुविधा कोन कि he will be always, the child's innocence will be spoiled. Every day he will be made aware that his father is a murderer. Now, without thinking that what impact it would have on the child's mind also. Mr. Mahapatra, I am sharing this with you, not passing order, because you must also understand the child's mind and what impact it would have if it is fed continuously that his father is like this. Because he will be seeking his identity. Even no 18 वर्ष की 12 वर्ष लगा he will start seeking his identity. Apanakara grief and grievance should not come in the way of child's development. Apana mane in the maternal grandfather's he may be convicted also. He may be convicted, so obviously he will lose the custody. Yes.
Item 13.
The Ganendra Chandra Swami for the petitioner. Opposite party blank. Yes, Mr. Swami.
Madam, the petition challenged the order dated 9/3/2026 by the Lawrence Civil Judge Senior Division Sundargarh, in which the Lawrence Judge has rejected the prayer of the petitioner not to allow her to give her evidence manner.
Kete adjournment nelendi?
First to do adjournment niyaitalaga. Tapos the intent is the only prayer of the petitioner, that the wife, that the area of maintenance amount has not been given to the concerned petitioner. So the counsel for the petitioner
When a husband ko maintenance magitile,
20,000 per month interim maintenance heitala.
Wife debe husband ko na husband debe wife?
Husband the wife.
Tale wife kor kai stock mane bond hegala evidence. Mane non compliance kon hela wife ko part re?
Wife बोले थे मुझे आदुस एविडेंस दे मुझे क्या टंका रे एडिटा से
सेमती कंडीशनल कोन कोर्ट रे हबो
कंडीशनल सिका इच्छित आगे देवा कथा
नहीं नहीं सेमती आगे आपण ट्रायल टाको केमती इंपैक्ट करिवे
सिका आगे हम कथा
मु तो भाबी आपण मध्ये सेक्शन 24 फाइल बाय द हस्बैंड
नहीं नहीं
सेमती आगे हबन आपण बुझांतु आगे आपण जदी कोर्ट रे कहबे मते पैसा दियंतु मु एविडेंस देबी ये की कथा आगे
नहीं पैसा इच्छित आगे सब्सटेंशियल अमाउंट तो देबा किछि देने
केमती करिवे आपण कथा मिस्टर पटनायक कथा आपण कथा बुझी लेखिबी ताले मते माने आई विल बी लाफ्ड एट एक्चुअली You must understand what you are ultimately what is your submission. आपण से कहिले that may be सुनंतु that may have some relevance, but does it have a legal relevance? जे आपण पैसा मते मेंटेनेंस मिलुनी मैं एविडेंस देबिनी इज इट नॉट आई थिंक आई हैव अंडरस्टूड करेक्टली और नॉट करेक्ट कौन
allow me permit those evidence. In the meantime,
आपण कोन गोटे एप्लिकेशन भी फाइल कर देले जे मु देबिनी एविडेंस पैसा पेमेंट
नहीं किसी application नहीं orally submitted कहते हैं और सीधा ऑप्शन
ऑर्डर देखांतो
that is page 30
पढ़ो 33 30
नहीं page 30 देखो 32
ऑर्डर डेटेड केते की
9/3/2009 page 34 में
हां से मु तो से को
33
पढ़ो सर
33
कोता ब्लैंक 33 पढ़ो
The record is posted today. Lawrence counsel for the petitioner as well as OP are present. On perusal of the case record is found that the same is posted for further order. On perusal of the order dated 23/9/2025, it is found that on that day petition dated 25/6/2025 filed by OP to be rejected as not.
आपण जे OP सर
I'm not the OP.
25/6/25 रे आपण कोन टाइम पिटिशन फाइल करथिले
Time petition.
लिखा है नहीं कौन पिटिशन
It's लिखा है नहीं time petition rejected matter and not moved since Lawrence counsel for the OP was absent. No, OP absent. And thereafter the record was posted 24/12/2025 for evidence from the side of the appeal. But on 24/12/2025, on account of avail by the PO, the record is posted to them. Lawrence counsel for the petitioner as well as OP files Hajira. On being asked about the witness which ought to have been examined, Lawrence counsel for the OP submitted that in view of the order passed in IN number 84/2023, one application is filed bearing number 5/2023 for realization of arrear amount, and it is also submitted that until and unless the entire arrear amount is realized, OP shall not come to the dock for giving evidence. Lawrence counsel for
आपण जो ब्रांच रे बसचंदी you have chopped up that tree. You should not have stated this before the court.
ना सेटा कौन से जस्ट तो जेतु ये लेडी ये वाइफ हो जे तो
एटा वकील कर एटा एडवाइस एटा लेडी कोन कहले आपण कोर्ट रे कहले मते मेंटेनेंस न देले म आसीबिनी एविडेंस देबिनी सेटा कोन गोटे वैलिड ग्राउंड जदी भी थिबो ताले यू हैव टू रेफर टू एनी प्रोविजन सीपीसी हो फैमिली कोर्ट्स एक्ट हो व्हाट इज दिस काइंड ऑफ
मैं humble people होता तू give permission to adduce or evidence to give time
23/4/26 रे कोन हैला आर्गुमेंट
23/4 से टाइम नेले जे
डेट केबे अछि
नेक्स्ट ई मे मास
आपण को दिन अपियर करके एविडेंस देबे एफिडेविट दियो देबे एफिडेविट काली
आसकल
ताले you see what you have actually I don't know how the lawyer could make this आपण जदी कोर्ट रे कंडीशनल अपीयरेंस रखिबे जे मते मेंटेनेंस देले म एविडेंस देबे सिंते कोन हबो होई परिबो
तो मोर आसुन देता
appearance लिखले hard lauded counsel for the petitioner wife in the marriage is before this court challenging order dated 9/3/2026 in mat 58 of 2023 the petition MAT 83 of 2023 has been filed by the husband in the marriage under section 13(1) of the Hindu Marriage Act. That called section 9 na 13 again.
13
of the Hindu Marriage Act seeking dissolution of marriage solemnized between the parties on 5/12/2007 and grant of decree of divorce. The order passed by the Learned Civil Judge Senior Division Sundargarh seems to be correct. The relevant portion is reproduced herein. The order is reproduced in पूरा order टा reproduce कर दियो scan करके कर the In considered opinion of this court, the petitioner, who is the opposite party before the learned judge, learned civil judge, senior division, Sundargarh, cannot impose a condition that unless she is paid the maintenance, she will not adduce evidence as opposite party. Para. Is submitted by the learned counsel for the petitioner that the petitioner shall file affidavit before this court stating that she will appear on who date could be she will appear on a particular date and adduce her evidence. केबे आसले affidavit देबे सर
काली
से अछनी petitioner को मिलिबे आपण तो कोर्ट राउरकेला ना कोन सुंदरगढ़ आस करिबे
डेट फिक्स हो जाए आफ्टर फैकेशन डेट फिक्स आफ्टर फैकेशन डेट फिक्स हो आफ्टर सबमिशन
particular date before the learned civil judge, senior division. Sundargarh and adduce evidence as required under law. So, for the matter shall be listed under the same heading in the week commencing. नहीं नहीं फिर जल्दी चाहते ना अपन 29 चौक में आज कितनी तारीख है 7 18 वीक रे आसीबे ना 11 वीक रे केबे आसले हम
18
in the week commencing 18 5 से 20 26 the affidavit on behalf of the petitioner shall be filed by the next date.
Item 14.
That's it. We have of Mr. Mohabitra break for a surplus. Okay.
So Sagar Das for the petitioner 15.
15.
May I please, Your Lordship?
Yes, please.
Here against the local order, I'm before Lordship, my lord. Order has been perpetrated, that's why I have come up, my lord. My lord, earlier I have seen that my lord was worried about the Dalasing letter judgment of.
I have issued written for judgment. I have also passed.
Yes, ma'am. That I know. I'm sorry, I have not gone. But that law is very clear regarding this. If there is fraud,
your ground is that how I mean fraud has been perpetrated on non-compliance of natural justice.
Yes, my lord. That I will mention. And let's hear
Sanjeev Kumar, how is he? He's Sanjeev Kumar of Sole or what?
My lord, what has happened here is suit for partition was filed. All the legal heirs should be implicated as a party. Annex 1 is the legal heir.
And the happenings not at Ramgarh.
No. And what
so Sanjeev Kumar should have been a party there.
Yes, my lord.
How he is interested?
Because he is the son of one Khageshwar.
Achha.
And his other brother sisters have not been made party.
Had learned counsel for the petitioner. The petitioner in the writ application challenges application under Article 226 and 227 of the Constitution of India challenges the order na award कौन सेड़ा function थी?
Award actually local the
award dated 13/12/25 passed by the
civil judge senior division Khariar.
Civil judge senior division civil judge into bracket senior division bracket closed comma Khariar. In
CS number 45.
CS number 45 of 2025, right?
Yes, ma'am.
CS number C.S. number 45 of 2025. In National Local Adalat, na kone?
This is local
in Local Adalat, National Local Adalat on 13/12/2025. By the said order, the petition under Order 23 Rule 3 of CPC filed by the parties to the CS on 7/11/2025 was allowed. It is submitted by the learned counsel for the petitioner that the petitioner herein is a necessary and proper party. He being the son of a co-parsoner of the Hindu family property.
Yes, ma'am. Hindu ancestor, joint family property.
Of the joint family property. He has not been made a party, nor any of his siblings.
Yes, ma'am.
Were made parties. Therefore, the mutual agreement and settlement on consent presented before the learned judge is vitiated and violative of the principles that the party should be heard. Now, he refers to the judgment rendered by this court. Now, ଆପଣ ପାଖରେ ଅଛି କିଛି ନାଇଁ
My lord, may I?
ସେ ଡିସିସନ ଟା ଜଲୋର ସିଂ ଫଲୋଇଂ ଗୋଟେ ଜଜମେଣ୍ଟ ଟ୍ରିବ୍ୟୁନାଲ ହେଇଛି Mr. Amit Bose and P.K. Satpathy. Amit Bose for the petitioner, P.K. Satpathy for the petitioner. Stop. Issue notice. ଏବେ ଆପଣ ଦରକାର ନାହିଁ ତାଙ୍କୁ ଦେବେ ଆପଣ ନାରାୟଣଙ୍କର ଅଲଗା ଜାଗା ନା issue notice along with this order to the opposite parties. Requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within 5 or 7.
My lord,
7 working days.
7 working.
In 7 working days. Returnable date be fixed to 29/26. The matter shall be listed for orders on in the week commencing 6/7/2026. IA 8432 of 2026. Hard nodded counsel for the petitioner. Stop. He reiterates his submissions as noted above. Stop. Issue notice. Issue notice as above. Accept one set of process fee as well as postal requisites. Thus, the returnable date as well as the next set of listings shall be as directed above. Stop. In the interim, it is directed that the order dated 13/12/2025 and the final decree dated
Annex 5. That is dated, my lord.
4/5/2026.
No, my lord, সেটা হচ্ছে 4/12/25
4/12/20
16/12/2025 16/12 16/12
16/12/2026
25
shall not be given effect to until further orders.
I'm sorry, my lord, that is actually 18 December. It has been mentioned 18 December.
16 ଭଳିଆ ଦେଖାଯାଉଛି
Yeah, ଉପରେ page 43, my lord. Second paragraph.
43 actually ଦେଖିକି କହିବି
Second paragraph, 18th day of December 2025. Second paragraph, before signatures.
sign ହେଇଛି 18 December.
Yes, no, that was prior to that it has been mentioned. Given under my hand and seal of this court, this the 18th day of December 2025.
ଆଗରୁ ଡେଟ୍ 16/12 ପଡିଛି ସେଟା ହିଁ ଆପଣଙ୍କୁ କହୁଛି
ହଁ ସେଇଟା 16 ଦେଖା ହଉଛି actually.
ନାଇଁ ତିନିଟା ଯାକ 16 ଲେଖା ହେଇଛି
ମାନେ
can be confident ଆପଣ ଏନାଉନ୍ସ କରି ଦେଖୁନାହାନ୍ତି
ସେ ମାନେ as you lords 18th
ବଟ୍ ଆପଣ ସିଏ ତ କହୁଛନ୍ତି ସେ signed on 18/12 କଣ ଦେଖିଲେ so final decree dated 18/12/2025 shall not be given effect to without leave of until further orders without leave of this court. The parties are directed to maintain status quo regarding nature, character, ownership of the property until further orders.
I love it. My lord, one more prayer I have. Actually, I mentioned that they have actually total 13 numbers of legal heirs. Out of the 3 have been made party in that suit. Rest and they have exonerated. That is why my fraud has been perpetrated and collusive decree was
I simply said about the petitioner.
No siblings has been mentioned. That is why my anxiety. 2 siblings were mentioned there. Others have not.
Some of the siblings.
Yes, but some of the siblings. Right.
Sibling जोड़ने it is some introduce करते हैं.
The number of frauds have been perpetrated here. Obliged. Or didn't come.
Urgent certified copy as per rules. Parties shall have the liberty to act upon the copy of the order obtained from the official website of this court.
Obliged.
16.
The Khiro Kumar Raut for the petitioner, opposite party blank. Yes, Mr. Raut.
May I please, President? The tune order is under Annexure 6, my lord.
Yes.
The Learned Hamil Judge Kendrapada, my lord, has directed the petitioner to pay the interim maintenance of 2,000 rupees, my lord. I have mainly challenged 3 grounds, my lord. The OP is an earning person, my lord. She is running a beauty parlor. It is admitted by her, my lord. And the petitioner has no income at all, my lord. and she has murdered the younger brother of the petitioner, my lord. The wife.
Written statement. You have to show me the written statement. These three things you have to show from the written statement and evidence, and how the court has dealt with that.
My lord.
Page
Kindly
55.
see my objections.
Page 55.
55. At paragraph 15, my lord.
And the minor son is also murder accused.
No.
See, he also runs a beauty parlor.
Son is major.
You must understand, you are arguing for 2,000 rupees.
My lord.
Because if the court analyzes that, that court seems to be having no mind also. 2,000 ଟଙ୍କାର ଆଜିକାଲି ଯୁଗରେ ଆପଣ minor son ଆଉ mother କୁ ଦେଲେ.
Not minor son. Son is major, my lord. She has falsely stated. Son is major. Date of birth of the son is 2006, my lord. She has falsely stated in her petition.
Application ଟା କେବେ କି?
2025.
ତ major କେମିତି ହେଲା?
2006 step.
2006 ରେ
ତ 19 ବର୍ଷ ହେଇଛି।
18-24 ଆପଣଙ୍କର ଯଦି ସେ ବ୍ୟୁଟି ପାର୍ଲର କରିନଥାନ୍ତେ ଗୋଟେ ତ 20,000 ପାଇଥାନ୍ତେ, ବ୍ୟୁଟି ପାର୍ଲର କରିଛନ୍ତି ବୋଲି 2,000 ପାଇଲେ। ଆପଣ 24 କରିବେ। ଆପଣ ବୁଝିବା ଦରକାର ଯେ earning of the wife is not a factor, only factor to decide this maintenance. Now I don't have that authority because the law is settled now. You must read that.
My content.
The law is very clear on that.
Milord, petition
ଆପଣ written statement ଦେଖନ୍ତୁ.
Yes. She has voluntarily left the matrimonial house, my lord.
Voluntary desertion is not a 125 na court petition.
No, এটা section 24.
କେମିତି prove ହବ voluntary desertion ଟା? ସେଟା 25 ରେ
evidence.
25 ରେ ସେଟା।
Yes.
ଆପଣ 25 ଟା 24 ରେ argue କଲେ କେମିତି ହବ? এটা pendant light maintenance.
My lord.
Who has filed the application under 13?
Husband filed.
So then it is pendant light. The petition alleging voluntary desertion is there to be adjudicated. So this court cannot take, not that court also. No court can determine. ଆପଣଙ୍କର final whatever will be decided, that's a different thing. ଆପଣ ସେଇ ଯୋଉ ତିନିଟା କଥା କହିଲେ କୋଉଠି statement ଦେଇଛନ୍ତି ଦେଖାନ୍ତୁ, witness statement.
Paragraph 15, my lord. Page 57. That Surjit Bhai, who is the opposite party number 2 in the original civil proceeding number 8 filed by the opposite party as petitioner, the adjacent neighbor of opposite party said Surjit Bhai and the petitioner. Petitioner means wife.
সেটা আপনাদের ইয়ে adulterous conduct. That cannot be a ground to deny because you have to prove it in 25. 13 ରେ 13 ରେ ଆପଣ ଯଦି adulterous conduct ନେଇଛନ୍ତି 13 ରେ କଣ ground ନେଇଛନ୍ତି? Adultery and desertion. It has to be proved. So that
is to be proved.
It is your case. You are alleging that the alleger cannot take advantage of the allegation. The court, I cannot direct that since the petitioner alleges adultery and cruelty or voluntary desertion, the petitioner wife is not entitled to any birth. For that, you have to get some case law. Wherever and the amount is 2,000.
2,000, my lord.
The language used by Honorable the Chief Justice Deepak Misra is that for reducing from 4,000 to 2,000, he has said non-application of mind by the High Court. It is not a fortune showered on the lady. ଆପଣ 2,000 ଟଙ୍କାରୁ କଣ ଡିଫାଇନ୍ କରିବେ ସେଟା ଫର୍ଚୁନ୍ କି ଫର୍ଚୁନ୍ ନୁହଁ? ଆଉ ଆପଣଙ୍କର lack of income is also addressed. Because if you are able-bodied person, kindly listen because what you are submitting is not law. It has to be legally nuanced. ଆପଣଙ୍କର ତିନିଟା ଜାଗା submission.
My submission is my lord. Law flows from the facts, my lord. Yes, my lord.
I will reject that.
Every case is different.
Every case is different, but not referring to law at all is a problem with you.
Yes, my lord.
ଆପଣଙ୍କର ଯୋଉ ଆପଣ ଯୋଉଟା କହୁଛନ୍ତି ଯେ she has own beauty parlor, yes, ସେଟା କୋଉଠି ଲେଖିଛନ୍ତି?
That is in the order.
Earning କଣ prove କରିଛନ୍ତି ତାପରେ proof ଦେଖେଇବେ?
No, in the order city at page 89. However,
the accused କୋଉଠି ଲେଖିଲେ?
However, the petitioner admitted that she had a beauty parlor.
ଆପଣ written statement ରେ କେମିତି admit କରିବେ?
No, it order sheet.
ଆପଣ ତାଙ୍କର ବ୍ୟୁଟି ପାର୍ଲର ର ଅର୍ନିଂ କଣ ଦେଖିଛନ୍ତି? ଆପଣଙ୍କୁ written statement ପଢୁଛି, ଆପଣ ଜଜମେଣ୍ଟ ପଢୁଛନ୍ତି?
ଲେଖି
କୋର୍ଟ ଦେଖାନ୍ତୁ।
at paragraph 16, page 58. That at the instigation and assistance of Surjit Bhai, the petitioner opened a beauty parlor at Olavari market.
ଆପଣ ସେଟା ପଚାରେନି ଇନକମ୍ ଫ୍ରମ୍ ବ୍ୟୁଟି ପାର୍ଲର କୋଉଠି ଆପଣ ଲେଖିଛନ୍ତି କଣ ପ୍ରୁଭ୍ କରିଛନ୍ତି ଆଉ ସେ ମର୍ଡର କରିଛନ୍ତି ଆପଣଙ୍କ ସେକେଣ୍ଡ ଆପଣଙ୍କ ଭାଇକୁ ମାରି ଦେଇଛନ୍ତି
The police has submitted charge sheet, my lord.
କେମିତି କହୁଛନ୍ତି ଆଜ୍ଞା what you are saying the law flows from the fact that is your contention or imagination or allegation
My
that cannot
contention.
be a ground
And also I have no income at all. Because my lord.
ସେଟା କୋଉଠି ଲେଖିଲେ WS ରେ କୋଉଠି ଲେଖିଲେ ଆଉ କଣ ପ୍ରୁଫ୍ ଦେଲେ ଆପଣଙ୍କ ଇନକମ୍ ନଥିଲେ ଆପଣ ଡେଲି ୱେଜ୍ ରେ ହେବ ଆପଣ 6-7 ହଜାର ଦେଇପାରିବେ ବୁଝିପାରୁଛନ୍ତି
Delhi କରିପାରିବେ ନା he is a plumber, my lord. He was in Maharashtra.
ସେଟା କହିଲେ ହବ ତ ପ୍ରୋବ୍ଲେମ ହଉଛି ସେଟା ସୁପ୍ରିମ କୋର୍ଟ ରେ କହିବି
My lord.
the law is like that ମତେ ଏଠି କହିଲେ ଇମୋଶନାଲ appeal I can't
No, my lord, due to murder of his brother, came down to his village.
Sir, that is not to be done.
After his mother.
You are convinced that due to murder of his court has to go by the evidence.
Evidence, exactly.
ଆପଣ you are impressed ଆପଣ ଜାଣିଛନ୍ତି let us assume ମୁଁ ବି ଜାଣିଛି but can I rely on that? No, I cannot. ଆପଣ କୋଉଠି ଲେଖିଲେ ସେଟା ସେ ଅର୍ଡର କଲେ ବୋଲି
ଲିଖିତ ମୁଁ ସେଟା ଭଲରେ ଦେଖିନି let it come next week. ଲିଖିଛନ୍ତି
ଯୋଉଟା ନାହିଁ ସେଟା କୁହନ୍ତୁନି that should be rejected. evidence କଣ ଦେଇଛନ୍ତି
evidence
ଆପଣଙ୍କର lack of income ରେ ଆପଣଙ୍କର that will be your
file କରୁଛୁ
ଆପଣ କୋଉଠି written statement ରେ କୋଉଠି ଲେଖିଲେ ନାହିଁ ବୋଲି
unnecessary 5 ରେ file କରୁଛୁ
written statement ରେ କୋଉଠି କୋଉ ପାରାରେ ଅଛି ଯେ ଆପଣ ଅନ୍ କରୁନାହାନ୍ତି ବୋଲି
paragraph 22 ହେଲେ page 59
अरे सेटा आपण ब्यूटी पार्लर लेक्चर
no no
actually I'm little bit ahead of you in reading it आपण कोठी लेखि नांदी आपण ऑन करू नांदी बोली कोठ लेखिले सेटा
लिखि दिबा the opposite party is frustrated jobless having no earning to maintain the petition
सेटा that plea that has been answered by Supreme Court two decisions including
next week my lord
no next week I can't waste time like that. I have to record your submission and reject it please appreciate I had lauded counsel for the petitioner. The lauded counsel for the petitioner is had at some length. The petitioner husband in the marriage is before this court. Challenging the order dated 5/3/2026 passed by the learned judge family court Kendrapada. In IA number 05 of 2025, arising out of CP number 25 of 2020. The said CP number 25 of 2020 is filed by the present petitioner seeking CP copy file करचंदी
again
seeking order section 13(1) of the Hindu Marriage Act 13(1) into bracket I-A into bracket I-B so the IA was filed seeking maintenance pendental light under section 24 of the Hindu Marriage Act. The petitioner in his plaint before the lauded trial court in the CP has admitted the marriage, stated that the marriage solemnized on 15/11/2004 is out of love affair between the petitioner and his wife in the marriage. He has alleged adultery as well as voluntary desertion. On part of the opposite party wife. As stated in the CP as well as in the objection to the IA, GR case number 18 of 2020. Rajkanika PS case, Kati Lekhundu, Rajkanika PS case number 230 of 2018 was initiated. The opposite party number one being one of the accused. Number one, wife being the accused. Stop. It is also stated that against the mother of the petitioner and others, GR case number 18 of 2020, the key section like page 47 Ranchi. Under section 147, 148, para 9 the said case is pending trial. Upon NRA जो case चल रही है trial is pending trial. To challenge the order directing payment of maintenance of rupees 2,000 per month, it is submitted by the learned counsel for the petitioner that the petitioner has the opposite party has voluntarily deserted the petitioner. He leads a adulterous life, and C is a adulterous life. Then next, and slow down. C is accused in a murder case, and lastly, the petitioner is incapable of earning. All the above please have been authoritatively dealt with by the Honorable Apex Court in cases where the husband in the marriage denies to pay maintenance by raising the grounds. That is in Samima Faruqi versus Sahid Khan. Petition Puradan. And in Rajneesh versus Neha. Petition The Lorded Counsel for the petitioner is apprised of the decisions and the law laid down therein. He submits that law, each case is different, and law. What is your submission? Law arises from the facts. Okay.
No. My contention is the law flows from the facts.
Law flows from the facts. On the face of it, the submission that law flows from the facts has to be rejected. Inasmuch as this court cannot ignore the settled propositions of law settled by the Honorable Apex Court. Of course, the facts are to be applied. The facts are to be considered without ignoring the legal propositions. No. It is fairly considered by the learned counsel for the petitioner that allegations made in the CP need to be adjudicated by the learned trial court, and finding is to be given on the same. So, the learned counsel for the petitioner has adjournment to address further. List in the week commencing after the before vacation, sir.
After vacation.
List in the week list for fresh admission in the week commencing after Panchi.
On
That before na after
Before that.
we commencing 18/5.
Obliged.
Yes.
Hon'Ble, password item.
Passover fresh admission.
Item 14.
ठीक अछि करो.
Password item 14.
Satyajit Mahapatra for the petitioner.
Petitioner is the wife Miller. Here, Miller, I prefer the order dated 19/26, Annexure 5, Act on Judge Family Court Miller. When they rejected the application order 7/11 of CPC Miller. The ground of Adjudication Miller, the husband opposite parties earlier filed a CP, Annexure 1 is the judgment Miller. By judgment dated 6/8/2022, the same has been dismissed. Again, the opposite party husband filed the present civil proceeding seeking dissolution of marriage Miller. That application, the petitioner filed in order 7/11 of
order 7 rule 11 रे केबे देखिचंती हिंदू मैरिज एक्ट रे डिजेशन क्रुएलिटी अलाउ हवा डिसीजन अछि impossible the impossibility being because each act of cruelty or desertion or adultery be a fresh cause of action. You can very well say that the new application refers to the earlier act. So that is how you will find that though the Hindu Marriage Act is of 1955, the concept of res judicata has not developed in Hindu Marriage Act in 13 way.
CPC applies.
आपको डिफेंड करिया पड़ियो डिफेंड करिया पड़ियो unless you take that plea upon say order 7 rule 11 रे plea टा नहीं चंती की जोटा मु अपन पचले I don't know because I'm just thinking like a lawyer.
No, that plea.
Then
no, I have taken plea that earlier CP.
Earlier dismissal of section 13 application can never be a bar for the subsequent application. Can never be. Because that is legally and factually impossible. Mr. Raut was saying that law flows from the facts. Here it's a mixed question of fact and law because you can very well say that on the self-same cause of action, that incident happening on so and so, that will be your defense in written statement.
Yes.
Already the court has rejected.
So
you are on a track where you are losing, you have lost the track. You, instead of defending your objective is to for grant of divorce, na support kurchon na oppose kurchon. Oppose kurchon. You want to continue the matrimony. So there you should have made an effort instead of filing order 7 rule 11.
My prayer, mediation.
Mediation facility कौन अछि
mediation ले उटे
Hindu Marriage Act रे आपनकर family court act रे court counselor अछन. We are broadening the mediation system in pending cases. Please appreciate this. Where there is a case statutory mandate without mediation conciliation, the court cannot proceed. Cooling off period. Whereas those facilities are not available for High Court. High Court can I refer to a counselor?
Legal aid.
Counselor, legal aid report counselor mediator
mediator
mediation counseling is a professional counseling is very important.
My humbly prayer lordship. This is matrimonial dispute.
Matrimonial dispute no order 7 rule 11 dispute.
No, order 7 rule 11.
Order 7 rule 11 ne mu kon mediation karibi. Dharo to mu karuchi. Ei to chhado to mediator jaha karibe. Apana kon karibe with your experience.
Chances of
order 7 rule 11 रे कोन mediation
order 7 rule 11 ले नै मन chances
आपण से जो प्लीटा सेठी नेबे ना जति आपनकर कोर्ट कन्सिलेशन को पठेबेनी फैमिली कोर्ट एक्ट mandates the court has to do it court रे counselor is appointed by the high court for that purpose only but high court is not appointing any counselor here. Family court counselor act and rule कोन पई because of that only they are professionals doing counseling and that is matrimonial counseling is an art, not a mediation between for a interstate dispute. Appeal stage re MATA stage re hochi because MATA stage re kichi nahi provision for counseling. So we have to refer to mediation. Upon order 7 rule 11 re hochi mediation kariya pe. आपनकर itself para 2 पढिबे जदि आपन application page 50 पढो just read it
page 50
हाँ 50 रे आपण बोलते I think that is 19(3) order टा जोटा
Yes, my lord. That is paragraph 2 re the shipping the present case is not maintainable as the petitioner has given false petitioner has false cause action. Earlier the petitioner has filed a divorce case. Shipping on 9/2008 on ground of desertion of cruelty. ता husband file कर
exactly
petitioner no.
সেটা তো কোন ল্যাঙ্গুয়েজ ভুলে তো সেটা লাগা সেটা আমি করনি আপন তা নাও লুক টু পেজ 42 para 3 that is stand up the wife or সেটা বুঝা পড়ুছি কোন লেখিবারে ভুল করে দেইতিবে
Page 42.
42 দেখুন para 3
Worth of a child respondent demanded for appointment of maid servant to take care of child when
earlier this petitioner has also filed divorce case CP number 92 of 2018 self-same ground of desertion and cruelty. CP case has been heard on length and now CP has not been continued more than 4 years. On 2022, this Honorable Court had dismissed the contest, the divorce case. So this CP is filed when?
The 24.
24.
Mile.
Se CP ta plate copy nahi madhe ade.
Yes, madam. That is
Wo page rech.
Annex 2.
2. I think you can have that plea at the stage of written statement. But outright it becomes almost difficult or impossible for a court to not to adjudicate desertion and cruelty in a matrimonial cause after even next stage. Those dismissal hela, next day gote cruelty hela. Kise gale hari desertion hela, voluntary desertion jota. Apono bade ki bahar kalta habani se palele.
The petitioner is now staying in parental house.
Parental house. So ଆପଣ ସେଟା କେମିତି ସେ plea ଟା କେମିତି sustain ହବ order 7 rule 11 କେମିତି applicable ହବ?
ମୁଁ adjudicata ରେ ଆସୁଛି ଯେ ଯେହେତୁ already
Adjudication in matrimonial year has not evolved. Unless that is how I am telling you that you may have that plea in your written statement that the same events were stated and it has been already considered and rejected.
WS already filed.
WS କରିବେ confront ବି କରିପାରିବେ. ଆପଣ cross examination ବେଳେ ବି confront କରିବେ. That much.
ତାକୁ କରିଛି.
ସେଠି ଆପଣ ସେ level ରେ ଆପଣଙ୍କର ଯଦି if you want mediation କିଛି ହଉନି ସେଟା ଅଲଗା କଥା. ଆପଣଙ୍କ priority ସେଟା ନୁହଁ.
ନା prayer
it becomes very difficult actually. This court must act judiciously.
Petitioner unnecessary.
You must understand that any suit being interdicted by the court prolongs the proceeding. We are pouncing upon the courts, breathing on their neck that why you are keeping the matters pending. And this is a cause of action of 2024. Already 2 years have passed. Now suppose I interdict and pass that whether order 7 rule 11 is to be allowed or not. It leads to nowhere.
At any stage also petition maintainable.
Can be, but it's a desertion and cruelty.
Unnecessary the petitioner running behind the court mirror.
Sir, that is your version. Recourse to legal remedy cannot be unnecessary. This is a basic.
Unnecessary means by instance of the husband.
Instance कौन husband को right नहीं 13 file करिवार और कौन can I direct that? Yes.
Dismiss आला पर पुणी after
he has rights, sir. It is a fundamental right or basic structure. Recourse to judicial remedy. Apart from being a fundamental right,
fundamental.
Basic structure, sir. Upon a basic structure, I will find fault. The husband goes to, then he will say that why the lawyer is filing. Could be, possibly, lawyer has instigated. If you make friendship with catch fish and make friends with fish. Very eminent judge used to tell this. No, କାମ କରିବା କଥା କରିବେ ଆଉ ଆପଣ କେମିତି କହିବେ ଯେ husband going to court is a act of unnecessary act. Then why the 13 is provided in Hindu Marriage Act?
Only one ground.
There is nothing. You talk to your client or the lawyer. The strategy the lawyer has adopted is not a proper approach. There is a basic difference between other suits, declaratory reliefs, and matrimonial suits or injunctions, everything. So, res judicata is never contemplated. But possibly you can say, take that ground in written statement and confront the petitioner. That is a possibility.
Written statement already filed on.
Confront karibe, say stand nebe. What written statement is stand nahi nahi.
Yes.
Then the court will evaluate whether this cause of desertion and cruelty was adjudicated or not. That is how Order 7 Rule 11 will come into play. But not this way, that every time the 13 application is filed, court will reject. Not even constructive res judicata. How do you say constructive res judicata? It cannot be, because this is a fresh cause of action. Yes, today or some other day you want?
Any other day?
Exam 14. So Satyajit Mahapatra for the petitioner, opposite party plan. The learned counsel for the petitioner is had at some length. The petitioner wife in the marriage is before this court. You can take your seat and take some 2-3 minutes to dictate the complete order. Challenging the order dated 19/3/2026 passed by the learned judge family court Baripada, Mayurbhanj in CP number 286 of 2024. Para 3 टा देखिले sir. Mr. Mahapatra. Para 3 टा पढ़िले से order. What I was discussing with you.
Yes, that.
So you should not have actually. You should have a very fair strategy to not to weaken your case in any manner. ଆପଣ ବର୍ତ୍ତମାନ ଏକ୍ସପୋଜ ବି କରିଦେଲେ ଆପଣଙ୍କ ଷ୍ଟ୍ରାଟେଜିଟାକୁ। ଆପଣ ଯୋଉଟା ରିଟିନ୍ ଷ୍ଟେଟମେଣ୍ଟରେ ଯୋଉଟା ପଚାରି ପାରିଥାନ୍ତେ କ୍ରସ୍ ଏକ୍ସାମିନେସନ କି ତାକୁ ପଚାରି ପାରିଥାନ୍ତେ ସେଟା ଆପଣ ଏଠି ଫାଇଲ କଲେ, ସେଟା କୋର୍ଟ ଫାଇଣ୍ଡିଂ ଦେଇଦେଲେ ଯେ କଜ ଅଫ ଆକ୍ସନ 5/9/24 ଆଫ୍ଟର ଦ ଜଜମେଣ୍ଟ ଇନ୍ ଏସଟି ନମ୍ବର 20/20 5/9/24। ଏସଟି ଟା କଣ ହେଇଥିଲା କି?
କ୍ରିମିନାଲ କେସ୍ କରିଥିଲେ ତାଙ୍କ ନାଁରେ, ସେଥିରେ କ୍ରିମିନାଲ
ଆପଣ ତାଙ୍କ ନାଁରେ କେସ୍ କଲେ, ସେ ଆକ୍ୟୁଟେଡ ହେଇଗଲେ।
ଆକ୍ୟୁଟେଡ ହେଲା ପରେ ତାପରେ ଏଟା ଫାଇଲ
ସେ ଗ୍ରାଉଣ୍ଡ ନେବେ false accusation
କିନ୍ତୁ ଯୋଉ ଫାଇଲ କରିଛନ୍ତି 13 ରେ ସେଇ ତ ନାହିଁ, ପ୍ଲିଡିଂ ରେ ସେଟା ନାହିଁ। ସେ
କ୍ରୁଏଲିଟି ଅଛି ପୁରା କହୁଛନ୍ତି,
ପ୍ରୋଭିଜନ ଅଫ ଲ ଟା ନାହିଁ, କ୍ରୁଏଲିଟି ଟା
କ୍ରୁଏଲିଟି ରେ ଆପଣଙ୍କର ସେ ଯୋଉ ଇଏ ଜଷ୍ଟିସ ଭଣ୍ଡାରୀଙ୍କର ଜଜମେଣ୍ଟ now it has come any kind of false accusation is a mental cruelty. Yes, कौन देखिए? Rejecting the application filed by the present petitioner, who is the opposite party before the learned judge family court under Order 7 Rule 11 of CPC. ଆପଣ rejection of plaint ପାଇଁ କହିଲେ?
rejection
literally seeking rejection of plaint.
Annex 3 in my petition.
Under purportedly on the ground of res judicata. Like constructive res judicata.
Res judicata.
The ground of res judicata. Yes. The learned counsel for the petitioner has referred to the pleadings of the earlier, the refer to the judgment dated 6/8/2022 passed with CP number 92 of 2018.
Annexure 1.
Annexure 1. He is also apprised of the position in law that Section 13, Section 13 of the Hindu Marriage Act contemplates a situation of filing of application on the ground of cruelty and desertion, which can be of which can be repeated occurrence, and each occasion shall lead to a cause of action. Stop. He seeks and has adjournment after vacation. List in the list for fresh admission in the week commencing 29/6/2024. Yes, next.
17.
None appears for the petitioner when the matter is called. The matter is listed for orders. Office note indicates that certified copy of the impugned order has not been filed and stamp reporting could not be made. The petition was presented before this court on 23/3/2022. Stamp reporting was made on 28/3/2022. The matter was listed before the Deputy Registrar into bracket judicial, law GMAT for removal of defects. On the said date, submission memory ka dichati. On the said date, after hearing the learned counsel for the petitioner, the following was observed by the learned Deputy Registrar. Quote karte bhe na 1/5/2026. Para. Quote kale page seta paime apna. Ta order re achi to order number 1. Accordingly, the matter is listed before the bench. In view of the categorical statement of the learned counsel for the petitioner before the Logima court or before the Logima court that he doesn't have any instruction and he will not press the application, the application stands disposed of. Stop. Yes, next, please.
18.
18 से mention कले कौन?
So,
Oh, कहले after the system. अच्छा, ठीक है लगा call करूँ. ठीक है जी. 18 passed over. 19.
19.
Appearing on behalf of the opposite party.
चले, let it be passed over. Any difficulty after recess?
No.
After recess, I'll continue.
Man.
You are mentioning any matter? Wherever both sides are present and agreeing for a date, he will give you the date.
Yes, I have taken consent of Ms. Shina.
37 upon date करतो.
Interim order to continue. मैं क्षेत्र खाली बोले ही ची.
नहीं, आपण करो sir. Interim order टा कौन adjournment ना stay अच्छी.
देखिए ना opposite party. से husband file करची.
ना ना.
मैं enhancement करची.
Stay रे कौन order कौन है इची सेटा पचार. Shall remain stayed. एंटी order है इची ना नहीं. Shall be adjourned. एंटी order है इची. Adjourn हेले after order करे पड़ेगा. Stay हेले तो I am not touching the order ना. They continues. Who order जान interim order.
Opposite party. Order dated 33.
Alok Das versus Pallavi.
आइए.
देखिए इस तरह.
हाँ. I think order dated notice was issued.
अच्छा, till shall remain stayed till appearance of the parties and till next date.
Subject to payment of 20,000. He has already deposited 20,000 मिला. Matter was listed.
ताले तो इधर next date of hearing अच्छी है. इधर किसी extend करे दरकार नहीं.
आइए. Okay, ମୁଁ ଏଟା enhancement file କରିଛି 419 ଟା ତ ମିଶିକି ଆସିଛି ୱିଥ୍ ଆସିଛି
right କେବେ ଆସିଲେ ହବ ଆପଣ କହିବେ ଚେକ୍ କରିଦେବେ but don't insist before vacation because before vacation we have already now handling around more than 200 cases
ଆଉ ସେ 419 ରେ ମୁଁ ଗୋଟେ କପି ତାଙ୍କୁ ଦେଇ ଦଉଛି
200 250 ହେଇଗଲାଣି ଆଉ
ଆଜ୍ଞା 419 ରେ ମୁଁ ତାଙ୍କୁ ଗୋଟେ କପି ଦେଇ ଦଉଛି
ଦିଅନ୍ତୁ but I am not passing any orders simply posting in the computer that saves time
I may be pardon my lord item number 20 ତାର କେବଳ notice ଟା ଯିବ on the question
ठीक है सर सेटा तो ऑर्डर करिया पड़ो आई कम बैक सर इफ यू आर नॉट देयर सर जदी मेंटेनेंस आपण दउ नांती दबा पड़ो
ना ना मेंटेनेंस दउची
देबे एफिडेविट देबे हबो कोनटा मते ऑर्डर तो पास करियो देबे
ना केवल नोटिस टा जीव
केवल नोटिस संगे मेंटेनेंस केवल भी दिया हबो बुझपरछंदी केवल मेंटेनेंस देबे तापर केवल नोटिस देबे से अपियर करिवे देयर विल बी समथिंग अदरवाइज इट बिकम्स ए फिशिंग एक्सपेडिशन जणा नै के मेंटेनेंस दबो के नबो केस कोन हबो
ना से आसिला जणा पड़िबो
केस सेठी पेंडिंग थिबो so this is how it becomes unpredictable just like you are catching fish by putting a fish rod say bhaya hoch
after lunch minute
yes I'm coming back sir please give me some time because there are so many because I find that since counsel are not appearing I just I can write now already time sir very time
Item 35 is a transfer application for relating to two civil suit. One is at Katak, one is at Puri.
Other side achunti
other side ମୁଁ ଗୋଟେ affidavit file କରିଛି ଯୋଉଟା ଆସିନି ସେଟା ଆସୁ ମୁଁ ତାଙ୍କୁ ଗୋଟେ
before vacation ଯାଉଛନ୍ତି
ନା ନା after
ତାହେଲେ କରିଦିଅ ତାଙ୍କୁ କହିଦେବେ
ଆଉ ଗୋଟେ adjournment ପାଇଁ interim order ଥିଲା ମୁଁ ତାଙ୍କୁ inform କରିଦେବି
ଏଥିରେ adjournment ଅଛି ତାହେଲେ ଏଟା extend କରିବାକୁ ପଡିବ ସେମାନେ ଆସି 3:30 ବେଳେ କହିବେ ଆଜ୍ଞା ଆମକୁ ଜଣେଇଲେନି
ସାର୍ ମୋର ଗୋଟେ affidavit ମୁଁ ଦେଇଛି
ସେଟା ଠିକ ଅଛି
ଏଇଥିପାଇଁ ଦେଇଛି
ଲେଖିକି ଦେଇଦିଅନ୍ତୁ ସେ ଦେଖିବେ ଆପଣଙ୍କର adjournment extend ହବ କେବେ ଡେଟ୍ ଚାହୁଁଛନ୍ତି
ଛୁଟି ପରେ ଯେବେ
ଛୁଟି ପରେ କେବେ କରୁ 27 ଭିତରେ ଆସିବ
ଆଜ୍ଞା ଯୋଉଠି ଯାହା ଆପଣଙ୍କ ବୋର୍ଡ କୁ କନଭିନିଏଣ୍ଟ କରିଦିଅ ଛୁଟି ପରେ
13/7 ଠିକ ଅଛି 13/7 ବି 13/7 ନା 27 କହୁଛନ୍ତି 27 ଠିକ ଅଛି 27 it will be adjourned beyond 27/7
sir
inform the other side
again item number 22
37 ଟା ଗୋଟେ ଡେଟ୍ ହଉଛି କେବେ ଡେଟ୍ କଲେ they are still further hearing ଅଛି already there check 37 କେବେ ଡେଟ୍ କରନ୍ତୁ 27 ମ୍ୟାଡମ୍ ଆପଣ
item number 22 pray for an adjournment
sir 22 ଟା ଗୋଟେ orders matter ଟା I'll pass that order I have to look it ଏବେ ଆପଣ ପ୍ରେସ୍ କରନ୍ତୁ
mention my lord
yes
yesterday there is list my lord the matter my lord
after notice matter ଟା
na after notice matter
ସେଟା ସେ distribute କରିଛନ୍ତି I have checked
my lord
जो matter ଗୁଡାକ ଥିଲା କେତେ 13 ଟା ନା କେତେ ଟା କହିଲେ 13 ଟା matter ସେ adjust କରିଛନ୍ତି
this order my lord your lordship be extended till 11 my lord Monday extended till 11 it may be extended my lord
नहीं सेटा आजी नहीं काली थिला काली किंतु टेक अप हेनी
ना
ताले आसंता काली माने सेटा कोन adjournment order थिला
ना ना adjournment
और स्टे थिला स्टे टा कोन एक्सटेंड हो केते देखिबे स्टे रे आ एक्सटेंड कोन हो स्टे तो स्टे ही अछि जस्ट लाइक यू हैव हर्ड Mr. Misra was saying the same thing but it is a state अच्छा टील थिला ओटा काली आनी आसे ऊपर डेट अछि ठीक अछि केटा काली आसीबो सेटा अपन त काली कहनी था
कहि दी थी
नॉट अवेयर ठीक तसी भी तो पर एडजस्ट करिवे ना मेंटेन द I'll consider
my lord Mr. Pradhan is
I understand sir Mr. Pradhan is difficulty Mr. Sahoo has to have food and go attend the things
pleasure
yes please Mr. Bhanti
sir 26 applicant रो हम दे देछु 10 women exempted 12 इनको सेट और चार जन करो 5708 paid through e payment system
37184
टोटल ही थिला My lord, ସେଥିରୁ 10 ଜଣ ହେଲେ noting out of 26 appellant 12 appellants women. ଆଉ income certificate ଦେଇଛୁ my lord ଆଉ 10 out 22. So out balance ଟା
ସେଟା ସେ SR କରନ୍ତୁ ହେଲା
my lord.
SR staff reporting କରିବେ. Subhanshu Bhushan Mahanti for the appellant, Mr. Ansuman Sethi for the Sethi, you are there?
Yes, sir.
Ansuman Sethi, additional standing counsel for the opposite party. It is submitted by the learned counsel for the appellant that though the deficit court fee is shown to be rupees 37,184. Dot 2.25 to be payable, and appellant number 3, 8, 21 and 23 have filed filing receipt of rupees 5780. Congar 3, 8, 21, 23 ମାନେ ଦେବେ କୋର୍ଟ ଫି
ଆମେ 4 ଜଣ ପାଇଁ ଦେଇଦେଲୁ 5000
ସେଟା 4 ଜଣ ପାଇଁ 5780 କି 37184 ଦେଖିବେ
ମାନେ ସେ ହିସାବ କଲେ ଅଫିସ ଯେ
ସେଟା ତ ମୁଁ ବର୍ତ୍ତମାନ ଷ୍ଟାଫ ଡ୍ୟୁଟି ହେଇ ପାରିବେନି ତେଣୁ ଆପଣ ତାଙ୍କୁ କହିଲେ ସେ ଯାହା କରିବେ ଆଉ
ଆଜ୍ଞା ହଁ ସେ 10 women ଆଉ ଆମ ଦେଇଛୁ 11
receipt of rupees court fee of rupees 5,780 stuff. Further SR be made whether the court fee amount has been satisfied or not, and if not satisfied, what amount is due to be paid by which of the appellants. So, the matter shall be listed for orders after vacation. With the week commencing on 30/6/2024. Registry shall do the needful. Yes, next.
Again. Item 19. May I pray? SR permission. Se senior man sହିତ consult kale. Senior man କହିଲେ ଯେ women exempted, income certificate holder जो ଦେଇଛନ୍ତି ସେ exempted. ଆଉ balance କୁ ତୋଡ଼ା ଦିଅ. ସେଇଥିରେ ମୁଁ ଏଟା paid जो 5000 something.
तो ମୁଁ ତ ସେ ଲେଖିଛି ସିନିୟର ଜୁନିୟର ଲେଖିବ ତା ଦେହରେ
ନାଇଁ ସେଟା ସମ୍ପୂର୍ଣ୍ଣ ମାଇଲା
rupees 5784 was paid after was paid after consulting seniors, and even when I have done SR even senior ଆମର advocates club को भी पचरा जाए केतरा जिंस that I have seen 26 years back I have seen that or 27 years back.
Dear sir को dear sir कहले एटा नोटिंग हो women exempted, income certificate exempted, balance to.
If it has been done, no problem.
ତାପରେ
ଆଉ ଗୋଟେ ଜିନିଷ ଆମର ଯୋଉଟା ନୂଆ ମାନେ ଆପଣଙ୍କ ନୂଆ ଲୋକ ଯିଏ ଏସଆର କରୁଛନ୍ତି ଷ୍ଟାଫ ରିପୋର୍ଟର କହୁଛନ୍ତି ଡୋଣ୍ଟ ଏକ୍ସପେକ୍ଟ ଦେମ୍ ଟୁ ବି ଦ୍ୟାଟ୍ ପ୍ରଫିସିଏଣ୍ଟ ଟିକେ ସର୍ଟକମିଂ ରହୁଛି
ଆଜ୍ଞା ସାର୍ ଏକ୍ସାକ୍ଟଲି
ହଉଛି ସେଟା ତେଣୁ ସେଟା ଗ୍ରାଜୁଆଲି ଦେ ୱିଲ୍ ଇମ୍ପ୍ରୁଭ ୟୁ ହାଭ୍ ଟୁ ବି ପେସେଣ୍ଟ ଆଇ ହାଭ୍ ଟୁ ବି ପେସେଣ୍ଟ ଆଇ ମିନ୍ କୋର୍ଟସ୍ ହାଭ୍ ଟୁ ବି ପେସେଣ୍ଟ
ସାର୍ ଆଜ୍ଞା
19 sir कौन कहले
opposite party my senior is on his legs from ground floor
नहीं एटा कोन एटा माने आपण बुझली पिटिशनर कांती व्हाट इज पिटिशनर ही ना एक्चुअली पास ओवर करबा कोछ
yes sir
ठीक अछि तो पुष्टि योर मैटर आइटम 20 कोन सीरियली एक्चुअली तो आगे तो रविंद्रनाथ पुष्टि फॉर द पिटिशनर
My lord,
opposite party black.
Revision I have filed challenging the judgment passed by the learned judge, family court Baripada,
yes,
on a petition filed under section 125 of CRP,
yes,
maintenance.
Yes.
As the revision could not be filed in time, I have filed an application for condonation of delay.
Apart from that, what is the status of payment of the arrear dues from 23/12/2023 5000 लेखे केते टका देछन subject to that delay will be condoned, otherwise delay will not be condoned. Apart from merit, delay will not be condoned.
I have to take instruction.
Take instruction. The petitioner had learned counsel for the petitioner. IA as well as it jaga likhiବାକୁ ପଡିବ IA 9 of 2025. The petitioner husband in the marriage is before this court seeking revision of the judgment dated 20/5/2024 passed by the Honorable Judge Family Court Baripada in CP number 67 of 2024. The said CP was initiated by the by the wife in the marriage under section 125 of the CRPC into brackets since substituted by pari materia provision, since repealed and substituted by pari materia provision. Section 144 of BNSS 2023 bracket closed. Then seeking maintenance at the rate of
say 7,000 to wife and 3,000 to his minor son.
for 7,000 for the wife and 3,000 for the minor child, one from the wedlock. The petition was favored. However, directing payment of rupees ଆପଣ ମାଗିଥିଲେ କେତେ?
ଆଜ୍ଞା
ଆରେ ସେ ଆପଣଙ୍କ ପିଟିସନ ଆପଣ 7,000 କଣ କହିଦେଲେ କଣ? କଣ ଲେଖିଲେ? ସେ ସେଣ୍ଟେନ୍ସ ଟା ଭୁଲ ହେଇଗଲା। ଲାଷ୍ଟ କଣ ଲେଖିଲେ? ପେମେଣ୍ଟ ପୂର୍ବରୁ ନାଇଁ seeking monthly maintenance dash for the wife and dash for the child. Petition.
page 23 order. The petition under section 125 of
ଆପଣ ଶୁଣୁନାହାନ୍ତି ସେଥିପାଇଁ କଣ ଲେଖିଲେ ପଢନ୍ତୁ seeking monthly maintenance at the rate of 10,000 per month for both the wife and the child. ଯୋଉଟା ଲେଖିନାହାନ୍ତି ଉପରେ the petition has been filed by the and wife in the marriage and the minor child born from the wedlock represented through mother guardian under section 8 seeking monthly maintenance at the rate of 10,000 per month. Very favored and granting 7,000 per month. From the date of filing of the application, that is 23.12.2023. The appeal, the revision has been filed after a reported delay of 109 days. The learned counsel for the petitioner is apprised of the decision of the Honorable Supreme Court in Rajneesh versus Neha, wherein it has been held that the amount awarded as monthly maintenance is akin to a money decree. In order to sustain the challenge to the amount, the petitioner, if so advised, shall file affidavit how he will secure the amount that is due till date. From 23/12/23 we was this must at least 1,40,000. That is for 28 months. They from 23/12 up to 23/4/26. 28 months into 5,000 into 7,000. Sorry. It is favored directing payment of rupees 7,000 to the wife and 3,000 to the child. The total amount due till 23/4/26 comes to 2,80,000. Yes, Quebec. How much time?
Vacation purpose.
Vacation purpose.
Vacation for yes.
The letter shall be listed for orders in the week commencing 29/6/2026.
Item 21. In 19, I appear for the opposite party.
Petitioner
There is an interim order which is operating against me. That order was passed on 13/9/2024.
Yes, 13/9/2024.
My lords, your lordships issued notice by speed post with AD and directed the matter to be listed. Now, no notice was received. Because this order was received in the court, my lords, I have appeared. They have not served any notice also on me. And the matrimonial proceedings has remained pending because of this order from 2024.
Yes, IA has been served.
IA, my lords, yes, copy has been served.
Then fix a date since he is not present. Which date you suggest?
Lords, you may call it.
After
Any
the
day next week we'll do.
Before vacation. Now petitioner none. So Devasis Ponda for opposite
No,
party.
I am for the opposite.
Devasis Ponda for the opposite party. Petitioner none. Devasis Ponda for the opposite party. None appears for the petitioner when the matter is called. Lauded counsel refers to the IA number 17 of 2026. That has been filed by the opposite party seeking vacation of the interim order, vacation of the modification of the interim order dated 13/9/2024, passed by the coordinate bench. Stop. It is submitted that copy of the IA has been served on the Lauded counsel.
The endorsement is there on the
Yes.
page 65 of the.
To grant further opportunity list in the week commencing 18/5.
Lords, how about next week? 18/5 will be the last week.
Next week,
Thursday, your lords, you may call it on Thursday.
date I cannot fix. Next week there are actually till now 115 matters. So that is how.
Let us take a chance.
Okay. List in the week commencing 11/5. Yes.
Item 21. My lords, on behalf of Mr. Pradhan is seriously ill, like paid for an adjournment. Can it be taken up next week, my lord?
21 पे
22, my lords.
और 21 पे जब तक पड़ो सफा just give me a second. Ms. Pratyusha Naidu for the petitioner. Mr. Opposite party के नाम दी. Opposite party none. Mr. S.K. Samantray. Senior panel counsel.
CGC, ma'am.
CGC. S.K. Samantray. CGC for the Union of India. The learned counsel for the petitioner refers to the order dated order stated order stated 11/3/2026 and 9/4/2026 and submits that instructions have been sought for from the employer of the petitioner regarding the income, regarding his income. The learned CGC submits that he may be accommodated further to obtain instruction. Stop. Accordingly, the matter shall be listed in the week commencing 13/7/2026 for orders. Interim order कौन थिला जଣା पड़ुजी पूर थिले The interim order dated 23/7/2025 passed by the coordinate bench. Sir, ये तापर extend ही नहीं ना कौन page consideration लिखे ले Right. The change got due to the learned counsel for the petitioner refers to the interim order dated 23/7/2025 passed by the coordinate bench and 6 for extension of the same. Stop. The interim order dated 23/7/2025 passed by the coordinate bench shall continue till the next date of hearing.
Item 22.
Your name, sir?
Shreyans Rajguru.
Shreyans Acharya.
Shreyans Rajguru.
Shreyans Rajguru. Mr. Shreyans Rajguru on behalf of Abhinandan Pradhan for the petitioner. Adjournment is sought for on behalf of the learned counsel for the petitioner due to personal difficulty. Stuff. The matter was earlier heard on 23/2026 at some length. The facts as well as the relevant issues of law. The facts as well as the legal issues were noted. To grant further opportunity to the petitioner, list in the week commencing 6/7/2026.
Item 23.
Listed for orders in the week commencing first. Yes. Indra Kumar Samal for the
Item 23, my lord, 1 week time may be granted to file the reply.
ତେବେ ଯେ ମୁଁ ଟିକେ ଖାଲି ନୋଟିସ୍ କୋର୍ଟକୁ ନୋଟିସ୍ କରୁଛି
A. Patnaik for the opposite party. Yes, Mr. Samal.
Kindly have a glance to your lordship's order dated 12/1/2026.
Shall I please?
Yes, please.
I will learn counsel for the petition. It is submitted that though the learned judge, family court, Bargott has noticed the occupation of the petitioner while deciding the amount payable to the maintenance as such under
ଆପଣ
section
କେତେ ଦେଇଛନ୍ତି କି maintenance?
7,000 ଦେଇଛନ୍ତି
ସେ ଦଉନାହାନ୍ତି ବିଲକୁଲ ଦଉନାହାନ୍ତି
ନା 7,000 ଦଉଛନ୍ତି ପଠଉଛନ୍ତି tele-
ଆପଣ enhancement ପାଇଁ ଫାଇଲ କରିଛନ୍ତି
ହଁ ଏନହାନ୍ସମେଣ୍ଟ ପାଇଁ ଫାଇଲ କରୁଛୁ ସେ ଟ୍ରାଏଲ କୋର୍ଟ ଗୋଟେ ରେକର୍ଡିଂ କରିଦେଲେ ସେ 8th ପାସ୍ କରୁଛି ଏତେ କୋଉଠୁ ଆଣିବ ଟଙ୍କା ଏତେ ଦବ ସେଇଥିପାଇଁ ୟୋର ଲର୍ଡସିପ
ନାଇଁ
ଡାଇରେକ୍ଟ
ଆପଣ ଶୁଣନ୍ତୁ ସାର୍ ଟ୍ରାଏଲ କୋର୍ଟ ଆକ୍ଚୁଆଲି ବନ୍ଦ କଲେ we discussed that maybe the education is relevant. Education is relevant also for that whatever post he is holding. ଯେମିତି extra departmental ଅବଶ୍ୟ BDBPM ର qualification ଥାଏ
नहीं नहीं ये EDBPM नहीं ये रेगुलर बैंक पोस्टल बैंक ब्रांच मैनेजर ही इज ए डिग्री होल्डर ऑफ MBA and he is drawing salary about 1,25,000 but his net salary is 67,000. We annexed the document as annexure 4. Lordship, if you lordship will
କେତେ ଦିନ ଆପଣ ଏଟା ପକେଇ ରଖିବେ
ଆଉ ଗୋଟେ ସପ୍ତାହଟେ
ଏଟା ଆପଣ ତ ଏବେଠୁ ପଳେଇବା କଥା ସେଠି ସୁବିଧା ହବ ଆପଣଙ୍କୁ ଆପଣ ଯଦି ସେଟା କହିବା କଥା ଏଇଠି ସେଇ କ୍ୱେଶ୍ଚିନ୍ ଉପରେ ଆପଣ ଯୋଉ ଡିଡକ୍ସନ ଗୁଡାକ ଆପଣଙ୍କର 2,25,67 ହେଇଯାଇଛି ଭଲେଣ୍ଟାରୀ ନା ଇନଭଲେଣ୍ଟାରୀ ଡିଡକ୍ସନ
ସେଟା ଆମ ଇନଷ୍ଟ୍ରକ୍ସନ ନାହିଁ ଗୋଟେ ସପ୍ତାହ ଖାଲି ଦିଆଯାଉ ଆର ସପ୍ତାହ ଗୋଟେ
ଆଉ ଗୋଟେ ସ୍ମଲ୍ ପ୍ରେୟାର
ୟେସ୍
ସେ ମନି ଅର୍ଡର କରି ପଠଉଛନ୍ତି ସେ ପୋଷ୍ଟ ପିଅନ ଯେତେବେଳେ ଯାଉଛି ମନେକର ସେ ନାହିଁ ଘରେ କୋଉଠି ଟିକେ ଯାଇଛି
ଆପଣ ମନି ଅର୍ଡର କରିକି ଆପଣ ଇଏ କରିଦିଅନ୍ତୁ
ୟୁପିଆଇ ରେ ଟିକେ
ଡାଇରେକ୍ଟ ଦିଅନ୍ତୁ
ହଁ
ହେଲା
ଆଜ୍ଞା
ଆପଣ ଫିସ୍ ଟା ବି ଡାଇରେକ୍ଟ ଦିଅନ୍ତୁ ଫିସ୍ ଟା ମନି ଅର୍ଡର ନା ଡାଇରେକ୍ଟ ଆସୁଛି
ସେ ଏଇଟା ବେମଗେଶ ତ୍ରିପାଠୀ ବେମଗେଶ ତ୍ରିପାଠୀ କେସ୍
ବେମକେଶ ତ୍ରିପାଠୀ କିଛି ଦଉନାହାନ୍ତି ପଇସା ପାଉନାହାନ୍ତି ଯୋଉଟାକ ବେମକେଶ ତ୍ରିପାଠୀଙ୍କ ପାଖରେ ମନି ଅର୍ଡର ପହଞ୍ଚୁନି ଆପଣଙ୍କ ପାଖକୁ ଆସୁଛି ୱାର୍କେବଲ ମନା କରନ୍ତୁ ବେମକେଶ ତ୍ରିପାଠୀକୁ କୋର୍ଟ ମନା କଲେ ନ ଯିବିନି It is the Lord's counsel for the petitioner refers to the earlier order dated 12/1/2026 and submits that the petitioner had adjournment to reply and the matter was directed to be listed on 2nd of February 2026. However, since then, no reply has been filed in response to the contentions raised on behalf of the petitioner. So, the learned counsel for the opposite party seeks further 1 week time. So, this further submitted by the learned counsel, Mr. Samal, for the petitioner, learned counsel to the petitioner that the amount of 7,000 now being paid towards monthly maintenance may be paid through UPI or directly credited to the bank account of the petitioner. So, in considered opinion of this court, the said prayer is convenient to both the parties. The opposite parties will pay the amount through UPI, like any online method, like IMPS, to the bank. List in the week commencing 18/5.
ୟୁପିଆଇ ନମ୍ବର ମେ ବି
ଅଛି ତାଙ୍କ ହଜବେଣ୍ଡ ଦଉଥିଲେ ଆମକୁ ଅଛି ଆମକୁ ଆଗରୁ ଦଉଥିଲେ
Item 24.
Before my
I am appearing in case of RPFM 418 of 2025 for the petitioner and in RPFM 387 for the opposite party.
Yes, Ms. Das. Das for the petitioner. Past RPFM is for what?
Your Lordship, there are two RPFMs. One is filed by the husband and one is filed by the wife and the daughter, Your Lordship.
So you want enhancement?
Yes, Your Lordship.
You want passment of the order granting?
Yes, Your Lordship.
Okay. So I think some other matter you have been hard and I have appraised you regarding all that was regarding transfer.
Yes, Your Lordship.
Yes. So on what ground you are challenging, seeking? You take your seat, Mr. Bhavan.
Madam.
Your Lordship, first of all, this has been a very long proceeding going on since 2003, Your Lordship.
Yes.
About 1, 2, 3, 4, 5, 6 proceedings have already been filed, Your Lordship, for enhancement.
No.
And
Ishika, there can be a competition actually. Odisha has achieved 37. Supreme Court has recorded 48 or more than that. So if you are saying 8, you must look at 37 and 45. Even to the extent the Honorable Apex Court has observed, they have choked the system. Because if you start in between them, they have filed 45 or 47 cases. Even other cases, definitely they lose their priority. And that too, the general pattern is that from the trial court up to Supreme Court, all courts, so many cases are filed. And obviously, the lawyers need not be worried about that. Lawyers are happy. Yes.
Your Lordship, the last one that was filed, which we are challenging now, they had filed to have the amount at 40,000, Your Lordship, for each of them. And we were directed to give 11,000 to each. We have paid, up until now, we have paid them the entire amount.
19-2024 order. What is that 99 order? That is RPFM 387.
387, yes, Your Lordship.
Yes. What kind of prayer dekhile? Just look at the prayer at page 11.
Yes, Your Lordship.
Improved order is dated 19-9-24.
No, Your Lordship, it's 17-3-20.
Yes, look at the judgment. So it can say, then how SR has been done? Staff reporting it there.
My apologies, Your Lordship. Your Lordship, the order is of 17th March 20.
Right, the judgment is, it's not an order, it's a judgment in fact.
Yes, Your Lordship, my apologies.
So it is enhanced from 11,000 for the mother and the daughter.
Yes, Your Lordship. Your Lordship, there was CRP number 128 of 2014, Your Lordship. It was 10,000 to be given to the wife and the 2 children, Your Lordship. After that, they have filed CRP number 46 of 2023.
Yes.
Wherein through the order of 17th March 2025, the amount was 22,000 in total. So 11,000 for the mother and 1 daughter. One other daughter has already been married, Your Lordship. To that extent also.
Look at para 17.
Your Lordship?
Para 17, running page 28, internal page 15 of the judgment. Or you can start reading from para 16 actually, that would be better.
Yes, Your Lordship. PW1 deposed that she has no source of income. It has been mentioned in the affidavit of assets and liability of OPW1 that the petitioner number 1 is earning by stitching clothes, making
body pampoda.
Body pampoda.
ताकू सेटा उसे अलगा कर देले body pa पड़ा कर देले ठीक अछि से इंग्लिश मीडियम में पढ़ी थिबे
and money lending.
Money laundering no, seटा laundering no. Money laundering is an offense.
I think it's Your Lordship.
Lending is also prohibited. Money lending has been since long prohibited. Anyway,
But there is no.
ऐसे पूरा ठीक है.
Yes, Your Lordship. But there is no document relating to the source of income of petitioner number 1, PW1.
So all these three pleas, stitching clothes, making body pampada and nailing money, you did not adduce any evidence.
No, Your Lordship.
What was your evidence? Like I purchased body at kg of so and so, pampada at kg so and so, or say stitching so and so. Anyway, you see the lack of enthusiasm for the client to adduce evidence results like this. Because whatever the lawyer does, it leads to nowhere. Yes, but there is no document relating to the source of income.
No, Your Lordship.
Did you ask the lady that you are preparing body and pampada selling it? What was your... It's better not to ask. If she will say that I am not preparing, then your entire case goes. Yes. Then read further. But there is no document relating to the source of income of the petitioner number 1. PW1 deposed that OP
is earning rupees 5,63,641 and the gross of rupees 1,75,147 for the month of January and February 2023. Admittedly, the OP is working under Railway Department in cross-examination in Para 27 OPW1. Admitted that he is working as grade 3 employee in Railway Department. The Xerox copy of the salary slip of the OP for the month of October 2022 is marked as Exhibit 18 in this case on behalf of the petitioner. The said Exhibit 18 has been confronted to the OP during recording of his evidence. The OP admitted the contents of Exhibit 18 as true. As per Exhibit 18, the net pay of OP is rupees 1,04,517 rupees. The OP admitted about the performance of his over duty. He also admitted that he used to get the payment for his over duty. The OP has filed the affidavit of assets and liabilities. He has mentioned about his hand loans, but he has not filed any documents to that respect. In the affidavit of assets and liability, the OP has mentioned about his net income per month as rupees 64,000.
hand loans kind coin city. Check the judgment on this. Judgment says involuntary reduction. Suppose now the OP takes a loan of 1 crore and says that I have become a pauper. Debt ridden, so I can't. That is not a ground to deny. So hand loan should not have been mentioned. Anyway, it is the choice of the party and the... Yes, mentioned about his net income per month is 64,071.
Yes.
How do you say that this 22,000 for the mother and child is less? Sorry, more.
Your Lordship, because his monthly expenditures have been...
Cannot be. It has to be reasonable. He lives a life of king size. So he wants to pay suppose 10,000. So at least he should live in 10,000 and pay the rest amount to the other parties. That is what the law is. It's not his choice or my choice or your choice.
Yes,
He lives like king size. He spends money. He goes everywhere.
Your Lordship, he has loans to pay, Your Lordship.
Loans has to be involuntary. Taxation. Read those two judgments. It is very clear. Ramima Faruqi and Rajnesh versus Neha.
Yes, Your Lordship. So,
You will take loan, become a king or a pauper. That is not impacting the court's power to grant maintenance.
Your Lordship, other than the maintenance, he has also given 4 lakh rupees towards the elder daughter's marriage, and also at one other occasion he has also...
Mother is not, the daughter is not seeking maintenance. Because that is a different thing. Seeking marriage expenditure in a proceeding is another proceeding.
Yes, Your
Not
Lordship.
in fact 125, that is...
That is, Your Lordship, Hindu Marriage Act, Hindu Adoption and Maintenance Act.
Maintenance Act, right.
Section 20, Your Lordship. Your Lordship, also 5 lakhs was...
He has purchased a 4-wheeler.
Yes, Your Lordship.
but does not like to pay to the wife and daughter. At times, it is very strange that how the contrary evidence is produced before the court to support one's case. In fact, the reasoning of now perhaps, I don't know whether what Mr. Mahapatra will argue. There is a possibility of this challenge to this reasoning. He purchasing a four-wheeler and purchasing a house, purchasing going to foreign trips, spending
Foreign
money.
trips, Your Lordship.
No. Can possibly how one go, because the argument is that I'm an independent human being. I want to spend the money I earn.
Yes, sir.
That argument has to be taken with a pinch of or a sack of salt. If you read the judgment, that it has to be voluntary or fast. You have a duty, legal duty, because the 125 is 15.3 legislation.
Yes.
Right of a woman to get be maintained by the husband. No case, madam. No case. It is very well reasoned actually. Rather, it has leaned towards you. I don't know what this Kulbhushan Kanwar versus Rajkumar in 1970 says, because that is now 70 means a little bit older than me. So I have to look at now 2021 and Justice Misra's judgment and Justice Indu Malhotra's judgment in Rajneesh and
Your Lordship, also the petitioners, Your Lordship, they are not, the wife and the daughter, they are not residing in a rented house as they had said, Your Lordship. They're in fact residing.
they may sleep on the street. They are destitutes. You see what argument is being assessed. Even they are staying at the, because the argument in one matter is that if they are staying with the husband or in his house, the court says that having a roof on the head is not enough. And in today's world, how they will spend 11,000 is nothing. Energy crisis has rendered everything costly. Yes, what do you say, Mr. Mahapatra? Okay, you are saying that it should be how much? Instead of 11,000?
I have to pray, we pray before the judge family court and 40,000.
40,000, yes, I marked that. And 40,000 is a total 40,000.
A total 40,000.
So instead of 40, he has granted 22.
22. Well, here the another aspect, since it has not been appraised to your lordship.
You take your seat.
Yes, sir.
The marriage of the present petitioners with the opposite party challenged this about the validity of the marriage. And that suit came to be dismissed for non-prosecution, and he has not taken any step for restoration of it, as he has admitted in his evidence. And in the so far the
he leads a luxurious life. He is already married to
another lady, and he is maintaining luxurious life, and I am being the
should be considerate, like your need.
Yes.
When somebody prefers to have more than one wife and so many children, you can be satisfied with 11. I will not interfere. No, today I am not asking you that. I am not compelling either of you. But this is what I am thinking.
But can he marry for the second time?
That question I am not to answer.
So no.
Morality wise, I cannot say. Legally, it has to be tested before the trial court.
Yes. But legality of the marriage with the present petitioner has already been decided. So it has
He
been
married the other lady for the first time or the present lady for the first time?
present lady for the first time, but he has made a deposition before the court for the first time in this present proceeding, not before the earlier proceeding, that I married to that lady in the first time. But now he is saying that that lady is my first wife, I was the second wife. And my marriage with
He has to please the other lady also. Whenever he meets the other lady, he says that you are I have married you. You are the only person in my life. That he has to tell, and how can he take a stand? Those questions are very difficult questions in cross-examination to answer.
And the status of the present petitioners before our lordship, and one is a major lady, marriageable age, and having multiple elements out the documents which
So,
have
enhancement because there are some logically the court is little bit has not considered that involuntary because the language used is
and that of being.
maybe in Rajneesh they have said this like this. The deduction has to be voluntary, involuntary deduction. You see, both Rajneesh and Samima just check that word voluntary. Samima has voluntary determined. It is there. So what is your suggestion? How much you will be satisfied? 15,000 each, or you will be sticking to 40,000?
Oh, my lord, see, we have paid 40,000. That means 20,000 each. It's equal to 20,000 each. I am leaving to your lordship to take a decision.
No, you are not agreeing for 11,000.
Yes, I am agreeing for 11,000.
No, agreeing in the sense because my first proposition is to take instruction if I do not interfere. Will they be? They agree for that. 22,000 ବର୍ତ୍ତମାନ ଯୋଉ ଅଛି 11,000 22,000 22,000 ଆପଣଙ୍କର client agree କରିବେ କି? I will not touch the judgment as such at the instance of them or by you. So that I can tell them that
part I will
at least they know that it is not being enhanced, but it can be enhanced. As I pointed to, he should have taken a car loan, a housing loan. All these things are not. These are voluntary. You take loan till you become a pauper. Suppose can that be a ground for court to grant? No, it cannot be. But you are continuing to receive କରୁଛନ୍ତି କେତେ ବର୍ତ୍ତମାନ?
ସେ ଆମର ଏନହାନ୍ସ ପଇସାଟା ଏବେ ଦେଇନାହାନ୍ତି ଆର୍ଲିୟର ପଇସାଟା ଯୋଉଟା ଆମେ ରିସିଭ୍ କରୁଛୁ ସେଟା ଦଉଛନ୍ତି 11,000 sorry 10,000 in total.
Your Lordship, as per my instructions, Your Lordship, there is an order dated 19th of December 2020. No, Your Lordship, not there. Your Lordship, it's a order of family court, Puri, Your Lordship.
Yes.
Thereby, Your Lordship, the petitioner, the husband has been paying Your Lordship in installments accordingly. In that order, he was directed to pay the amounts in installments.
Settlement of the first amount or the second amount?
Your Lordship, directed to pay 11,000 per month to each petitioner, so that is 22,000. Your Lordship, he has been paying, Your Lordship. So in 7 installments, Your Lordship, he has been asked to pay the said amount, Your Lordship. So he's paying that.
No, installment means area, because usually the order for the is by 10th of the next month. I'm
yes,
just
Your
giving an
Lordship.
example.
Yes,
The
Your
amount shall be paid by the 10th day of next month. So January is February 10th, February is March 10th, like that.
Yes, Your Lordship. So that, Your Lordship, that
And
was
also there is since there is an order to do this enhancements to be given effect from the date of application of 2023.
Yes.
So some measures were there.
Yes, Your Lordship, that areas from 1st of
1
May.
2023 ରୁ 17/3/25 ପର୍ଯ୍ୟନ୍ତ ଯୋଉ differential amount.
Your Lordship, till 24th of December 2025. Yes.
Only about the liabilities both. Both ghara, both gadi, both
ସ୍ତ୍ରୀ.
Your
so many ladies around, so he's surrounded
Your
by.
Lordship, even the wife was married before the husband, Your Lordship, before marrying the husband.
Hey, set up the bond age. That is the simple one line plea you have to take it that because maintenance 125 and 25 both say till the lady marries.
Yes, Your Lordship.
So that is a ground for you to stop her payment of maintenance.
That point he has raised.
As fact is stranger than fiction. Now, who was married, who is married when and to whom? This is a very situation. But anyway, if you are agreeing for that 11,000, I'll just sustain the order. But today I'm not passing that order. Obviously. First matter lecture. RPFM 387, Mr. Ranjan Mahapatra.
Your Lordship, a small request. We haven't received the copy of
Second
the...
Yes. Just wait. I'm just dictating the order in the first one.
Yes.
The petitioner husband in the marriage is before this court. Any other proceeding pending between the parties? 13(9).
No, other proceeding is pending and filed by the present petitioner regarding declaration of marriage.
Dismiss ହେଇଗଲା.
ନା ଆମେ ମୁଁ ଫାଇଲ କରିଛି କାରଣ ସିଏ ତାଙ୍କର ସର୍ଭିସ ରେକର୍ଡରେ
declaring the marriage to be valid.
Marriage to be valid and to recording the person's nominee in the service record that he has recorded in the service record in the name of the second wife instead of my name. So that I have
ଦେଖିକି ବାହାଘର ହେଇଛି ତାଙ୍କର ସେଥିରେ
ସେଟା ଆମେ ଚ୍ୟାଲେଞ୍ଜ କରୁଛୁ ସେ ପ୍ରୋସିଡିଂ ଟା ପେଣ୍ଡିଂ ଅଛି ଏଇଠି ମ୍ୟାରେଜ ବାବଦରେ କିଛି ମ୍ୟାରେଜ ତାକୁ ସେ ମଧ୍ୟ ନିଜେ ଆକ୍ସେପ୍ଟ କରିଛନ୍ତି there was a marriage and that was registered. For the first time, he is raising that that lady was my first wife. This lady, I am married for the second time.
No, regarding matrimony, no other cases are pending.
No other cases.
So he has not sought for any divorce.
No. ସେଟା ଯୋଉଟା ଫାଇଲ କରିଥିଲେ ସେଟା dismiss ହେଇଯାଇଛି. Even original grant of entitlement of the maintenance ବି ସେ କେବେ ଚ୍ୟାଲେଞ୍ଜ କରିନାହାନ୍ତି. 125 order କେବେ ଚ୍ୟାଲେଞ୍ଜ କରିନାହାନ୍ତି. ଏଇଟା 127 order ଯୋଉଟା ଏନହାନ୍ସ ହେଲା ସେଇଟାକୁ ଚ୍ୟାଲେଞ୍ଜ କରୁଛନ୍ତି. So that your lordship that unless
notice that.
Unless he challenges the original order subsequent
enhancement ଯେତିକି ହେଲା ସେତିକି ଚ୍ୟାଲେଞ୍ଜ କରୁଛନ୍ତି ଆଉ. ଗାଡି ଲୋନ ନେଇଛନ୍ତି
40,000 ଟଙ୍କା ଦଉଛନ୍ତି ବୋଲି ଲେଖିଛନ୍ତି ଇନଷ୍ଟଲମେଣ୍ଟ କୋଉ ଗାଡି ନେଇଛନ୍ତି କଣ 40,000 ଟଙ୍କା ଏମିତି ମାସକୁ ଇନଷ୍ଟଲମେଣ୍ଟ ଦଉ ପଡୁଛି Mercedes ନେଇଥିବ
seeking challenging the judgment dated 17/3/2025 passed by the learned judge family court Puri in CRP number 46 of 2023. The Purpur lekhontu what opening sentence lekhontu the learned counsel for the petitioner submits that inadvertent typographical mistake the inadvertent typographical error has crept into the prayer within court prayer paragraph at page 11 of the petition, wherein the impugned order has been mentioned to be of date 19/19/19/9/2024. Stop. It is submitted that it has to be read as the judgment dated 17/3/2025 as at Annexure 1. Stop. She seeks leave to correct the same by carrying out necessary correction with pen in the court records. Prayer of the Learned Counsel is allowed. She shall correct the prayer paragraph as indicated above. It shall contain her initials to be countersigned by the court master. The petitioner husband so and so challenged the order of judgment dated 17/3/25 passed by the Learned Judge Family Court Puri in CRP number 46 of 2023. The said CRP has been filed under section 127 of the 127 of the CRPC seems repealed and substituted by perimeteria provision dash of BNSS 136 posted 146 of BNSS bracket closed. For enhancement of maintenance granted by order dated 24/11/2013 in CRP number 254 of 2012 corresponding to criminal miscase number 33 of 2003. The Learned Counsel for the petitioner is heard at some length regarding scope of interference by exercising the jurisdiction, exercising the revisional jurisdiction, scope of interference in the order passed by the Learned Judge Family Court under section 127 CRPC by exercising revisional jurisdiction. She has adjournment to address further. Stop. In response, the Learned Counsel for the opposite party submits that the RPFM number 387, RPFM number 418 of 2025, which is listed, which is tagged, is filed by the opposite party wife and daughter born from the wedlock, seeking enhancement of the monthly maintenance. So, the matter shall be listed in the week commencing after vacation or before vacation?
Your Lordship?
After or before vacation?
Your Lordship, if after vacation.
Shall be listed for orders in the week commencing 6/7/2026 ହେଲା ଆପଣ ଲିଖିବେ ନେକ୍ସଟ ଅର୍ଡରଟା କରିଦେବେ ଆରଟାରେ RPFM 418/2025 ମିଷ୍ଟର ଦୀପ୍ତି ରଞ୍ଜନ ମହାପାତ୍ର ଫର ଦ ପିଟିସନର opposite party blank. The matter is listed along with the connected RPFM 387/2025. Ms. A. Das, Learned Counsel, submits that she has instructions to appear on behalf of the opposite party. She may be provided with a copy of the application. How much time to file Wakalatnama?
By next week, Your Lordship.
She prays for, she submits that she shall file the duly executed Wakalatnama on behalf of the opposite party within 7 working days. Upon filing of the Wakalatnama, sorry, upon copy of the application shall be served within 2 working days. Copy of the application shall be served on
by Monday also, by Monday. By Monday also.
Okay. The copy of the application shall be served on the Learned Counsel for the opposite party by 11/5/2026 or within 3 working days. Within 3 working days. Upon filing of the Wakalatnama, the same shall be taken on record, scanned copy be updated. Name of Ms. Das and Learned Counsel. Mr. Parida will appear.
Yes, sir.
The name of Mr. Prabhas Pujari Parida, Learned Counsel. Ms. A. Das, Learned Counsel, and Learned Associate shall be mentioned in the cause list as well as the case brief. The matter shall be listed along with RPFM 387. 6-7 पहले. For orders in the week commencing 6-7 20-24. Yes, Mr. Mahapatra.
ଦିଟା ଯାକ ଯୋଉ ଡିଲେ ଥିଲା ଯଦି ଆଜି ଡିଲେଟା ଦିଟା ନେଇଯାନ୍ତା ବେଟର ଆଡମିସନରେ ପଳେଇ ଆସିଲେ ଫ୍ରେଶ ଆଡମିସନ.
This is being heard for fresh admission only. Delay is not an issue because both of you have filed. Okay, order se asu.
ମାନେ ବହୁତ ଦି ଜଣଙ୍କର ଡିଲେ କଣ୍ଟ୍ରୋଲ ନେଇ ଫ୍ରେଶ ଆଡମିସନରେ ପଳେଇ ଆସିଥିଲେ ଆମେ ଟିକେ ବେନିଫିଟ ହେଇଥାନ୍ତୁ.
ନାଇଁ ଆପଣ ତ ବେନିଫିଟ
ସକାଳୁ ସକାଳୁ ଫ୍ରେଶ ମାଇଣ୍ଡରେ ଟିକେ ଶୁଣାଣି ହନ୍ତା. ଅର୍ଡର
ଆପଣ କଣ୍ଡୋନେସନ ଅଫ ଡିଲେ ଆପଣ ସର୍ଭ କଲା ପରେ ଆଜ୍ଞା ଓକିଲଙ୍କ କଥା ଗୋଟେ ଭାବିବେ ନା ସେ ଗୋଟେ ଅବଜେକ୍ସନ ଫାଇଲ କରିବେ କି ଆପଣ ଅବଜେକ୍ସନ ଫାଇଲ କରିବେ ଦେयर ସୋ ମେନି ଥିଙ୍ଗସ୍ ତାଙ୍କର ଓକିଲତନାମା ହିଁ ନାହିଁ ସେ ତାକୁ ଏନଗେଜ କରିବେ କି ନାହିଁ ତା ବି ଠିକ ନାହିଁ ସେ ଆପଣଙ୍କୁ ଏନଗେଜ କରିପାରନ୍ତି ସେ ଇମ୍ପ୍ରେସଡ ହେଇକି କି ଜାଣିଛି ଆଉ ମିଷ୍ଟର ବୋସ୍ ମେ ବି ଏନଗେଜ ଯାଉ ସେତେ ବାଟ ଯାଉ ଦେଖିବା ୟେସ୍ ଅର୍ଡର ସବୁ ଭୁଲ ହେଇଗଲା RPFM 387 ରେ ଗୋଟେ ଆଡ୍ ହବ ଆରମ୍ଭ. Office note put up by the registry indicates that the serial number of order dated 23/9/2025 ସେଇଟା ବୋଧେ ଠିକ ଅଛି. Serial number of order dated 10/12/2025 has been wrongly typed as order number 1 which should be order number 2. ଆଉ କୋଉଟା ଭୁଲ ହେଲା? Order number 2. The necessary correction be carried out in the said order. But se order ta to mu pass karune apan mate kujhe kare Accordingly, the order dated 5/5/2026 shall be order number 3. Order number 3. The order dated 5/5/2026 shall be corrected in accordance with the rules. तापरे जोटा typographical error ता এটা সেটা add হবো খালি বাকিটা সে করতেই চলে. Yes.
Item 25.
Mr. C. Vidyabhushan for the petitioner. Yes, S.L. Sinha for the opposite party. The matter being listed for orders, matter having been listed for orders is mentioned by the learned counsel for the appearing parties at the beginning of the day's proceeding. Stop. This is a good cost title କରିବାକୁ ପଡିବ ହେଲା TRPC 325 of 2025 385 of 2025. The petition report ଟା କୋଉଠି ଅଛି? TRPC, both the TRPC 325 has been filed by the wife in the marriage. Whereas the connected TRPC 385 of 2025 has been filed. No, again, sorry, both the TRPCs have been filed by the wife in the marriage, the husband being the opposite party in both the cases. The matter was referred for mediation by order dated 9/1/2026 of the coordinate bench. Mediation has become successful. The report dated 6/4/2026 of the learned mediator is on record. The report indicates thus. I persuaded and generated various points to Neki. Hence, the mediation became successful. So that quote here. तापरे देखिए मेमो dated 20/4/2026 has been filed by the learned counsel for the petitioner, which states thus. In memo dated जो इतने लिखिले has been filed in TRPC 325 of 2025, which states thus. तापर लिखिए मेमो डेटेड 4/5/2026 has been filed by the learned counsel for the Chaudhary case. The learned counsel for the petitioner, which states thus. Quote here. In view of the above, both the TRPC, both the applications, that is TRPC 325 of 2025 and 385 of 2025 start disposed of. Second matter is केंती करे ना computer है करे नहीं अलग करी करे पड़ो नहीं joint अपन joint order टा कले गोटे का सेट रहला प्रथम रे order टा रहला second रे देखिए करिवे कोटे दो yes next
26
petitioner none, opposite party blank, none appears for the petitioner when the matter is called. तो बोधे appear करते ले एठू remote location नु कि अछंदी कि नांती मत सिटी virtual portrait के नाम दो. Petitioner none, opposite party blank. On 23/4/2026, the matter was heard at length. Today it is listed for orders. Stop. On the said by order dated 23/4/2026, the facts as well as the legal issues were noted. Granting for the time to the learned counsel for the petitioner to advance arguments. Stuff. None appears for the petitioner when the matter is called. To grant further opportunity, list in the week list for orders in the week commencing. 6/7/2026.
27.
Well, 27, I am for opposite party number 1. Well, here, the order which is challenged before your lordship is the allowing of an application under Order 6 Rule 17 for amendment of the written statement filed by the wife. My lord, merits.
If you look at the first paragraph of that amendment application, just straight away go there.
Yes.
Amendment application, first paragraph, page 161.
Yes, my lord, they have deposited the requisites. My senior must have deposited the requisites.
No, that is how I was, because that is how I remember.
Yes.
It was so recently argued.
Yes.
So that is how, in fact, I have not looked at it, but I
No, my lord, here
you take a copy.
Yes, I'm seeking a modification of your lordship's order because the Order 6 Rule 17 which has been allowed, your lordship has been kind enough to issue notice. I'm not on merits now. Merits your lordship may decide later or subsequent whenever your lord. My lord may kindly see my lord's order. In IA number 6769 of 2026.
Yes.
It is directed that the copy of this order shall be placed before the learned civil judge senior division Talchen in case number something set. It is stated before this court that cross-examination of witness is going on. It is directed to cross-examination shall continue. The learned family court shall not refer to the amended written statement in the pending proceeding till 13/7/26. however, without in any other manner restrain itself for adjudicating the matter. My lord, now the problem is, suppose.
No, Mr. Bose, then since it is very recent, so Mr. Sharma is aware. Actually, my view was to adjourn it.
Yes.
So then he said that it is my petition.
Yes.
That is how
Yes.
it would have been adjourned.
Let me assist your lordship. Now what has happened? Your lordship has directed that the amended provision, amended written statement or the amended portion shall not be referred. His witness, my lord, I filed a time petition on the date fixed.
No, let it be adjourned.
Yes, I only want that let it be
I understand. I understand. In fact, if you can check with Mr. Sharma and Learned Junior, this was discussed.
Yes.
But his concern was that since this is my application, so
now what has happened?
I don't know. You are saying that to be fair to both the sides, let it be adjourned.
Yes. Because now his witness he has closed.
I was expecting another argument from you that if your written statement will be ultimately allowed to be amended, then your cross-examination would be different.
Yes. And my questions will to the petitioner's witness will be also different.
But anyway, since you have appeared as expected, so you have not received copy.
No.
Say adjourn nahi ki rahu. To be fair to both the sides, let it be adjourned.
Examination of witnesses from my side is closed. She refused to cross-examine my witnesses. From today onwards, she is supposed to produce her witnesses.
No, Mr. Sharma, it is like this. Suppose now I rejection of order 6 rule 17 you have challenged.
No, allowing.
Sorry, allowing order 6 rule 17 you have challenged.
Yes.
So either way it will affect the pleadings. Me accepting the order of the court or rejecting the order, altering the order of the court, overturning the order of the court will affect the pleadings.
No, let them file a petition seeking adjournment. The court will decide.
Yes,
he rejected. He rejected my petition.
No. Because I was being cross-examined. So cross-examination allowed. Cross-examination of PW1 completed. They refused to cross-examine further, and PW2 also they said will not cross-examine. Then the court says, please produce your witnesses. What is wrong with this, my lord?
It has to be adjourned because I anticipated this thing because that way if you remember, we were discussing this. The reason being, suppose
let them make
now
decided on its own merit.
Yes, it is
amended written statement. How do you expect that the same obvious?
Sir, I am conscious of everything. I am not running away the.
So that is how you say that it has been noted. That cross-examination, of course, I was not sure whose witness is being cross-examined. That was not the
PW1 was being cross-examined.
PW1 is the husband.
My lord, I am coming. I'll not withhold any information from the court. PW1 was being cross-examined when this application for amendment was filed. Rightly, wrongly, your lordship will decide whether the amendment will be sustained or not. That is the ultimate result. When this order came, I filed a time petition that I want to seek a modification of the order because I will not further cross-examine because this amended portion I have to also put a question. The court below rejected my time petition, declined that PW1 will be closed. PW2 when was produced, I have said that I will not cross-examine. Declined, closed PWs. Now he has posted the matter today for my evidence. My lord, what evidence I'll give? If ultimately your lordship...
You have heard the learned senior. He agrees there.
Yes.
Your evidence will definitely refer to your written statement.
Yes.
Which subject matter now before this
yes.
court. এটা কেবে গছি
স্যার
6-7
ଆଜି ଥିଲା
ନାଇଁ ଲେଖା ହେଇଛି ଗୋଟେ 6-7
6-7 ସାର୍ ଆପଣ ରଖିଛନ୍ତି 6-7
In all fairness, the lordship should grant me few days time to file an objection to this. Otherwise, I'll be misunderstood because
no.
He has not this a copy.
No, you cannot be misunderstood. This is a classic case where the court will be misunderstood. because the interim order,
act of court prejudice none.
No. It at times that is how that maxim is there. It should not prejudice none. So now, because of this order, actually, the court will proceed in her examination actually.
And there is an order from this honorable court to complete the entire proceeding by 10th of May 2026.
So that I told that day, that there are so many innovative ways to do things. So ଆପଣ ଆଇଟା ସର୍ଭ କରିଦିଅନ୍ତୁ ଆଜି
କରିଦେଇଛି ସାର୍
କର
ସାର୍ ମେମୋ ଦେବି ମେମୋର ଜେରକ୍ସ ବି ରଖିଛି
ନାଇଁ ଠିକ ଅଛି
I have received it.
no you reserve your right to reply, no difficulty, because by adjournment of the matter no one is prejudiced, neither you. So suppose you are prejudiced that way, so I mean what can be done?
I'll come again before your lordship.
I mean by simple adjournment of a matter, but deferment of a matter, only a deferment of a matter. IA 8572 of 2026. The IA has been filed by the opposite party with the following prayer. The copy of the IA has been served on the learned counsel for the petitioner during course of the day. Aji dele.
না না
Sir, kali likhna.
স্যার গতকাল
Has been served recently. Got served on aji tarikh kete aji hochi 7/6 on 6/5/2026. Appearance likhe Mr. Bigyan Kumar Sharma, senior advocate, along with Mr. S.K. Singh for the petitioner, Mr. Amit Prasad Bose for the opposite party. IA has been filed by the opposite party. ठीक है. The learned counsel for the opposite party refers to the interim order as noted in paragraphs 5 and 6 of the order dated 34/2026 stuff. He submits that as on date, the matter is posted to kete tarikh ko utare?
ଆଜି ଥିଲା ସାର୍
As on date, my matter was posted to 7/5/2026, that is today. The cross-examination of PW1 petitioner complete hichi na kar
1-2 closed
the examination of PW1 and 2 has been closed
as declined
by the other side to cross-examine the said witnesses. Stop. The learned judge family court has fixed the matter for examination of the opposite
Defendant.
party.
Opposite respondent witness.
Set your respondent.
Respondent 1.
Who is the respondent number 1 before the learned judge's family court? So, he submitted that in all fairness, the matter should be adjourned till the present application is considered and decided by this court. That is regarding the order dated 30/03/2026 passed by the learned judge family court, the learned civil judge into bracket senior division Talche, allowing the application filed by the wife in the marriage under order 6 rule 17 read section 151 of CPC, allowing amendment of written statement. Stop. They submitted that since based on the written statement the wife has to depose before the learned trial court, no prejudice would be caused to either of the parties if the matter is deferred. The further proceeding before the learned trial court is deferred. Stop. In response, the learned senior counsel for the petitioner submits that he shall obtain instruction in the matter. The learned instructing counsel submits that the matter is posted to 12/5/2026. So, having heard the learned counsel for the petitioner and the opposite party, the order dated 30/4/2026 in IA number 6769 of 2026 is modified to the extent that upon a prayer being made before the learned court in learned civil judge senior division so and so, the matter shall be adjourned to a date.
Sir, upon 6-7 को रखचंद. Be commencing 6-7.
Shall be adjourned to a date beyond 13/7/2026 as would be convenient to the learned court in season of the matter. The present application shall be listed before this court in the week commencing 6/7/2026 as directed earlier.
A copy of the writ petition may be served on.
It is submitted by the learned counsel for the opposite party that he may be provided with a copy of the writ petition. The learned instructing counsel shall provide another copy of the writ application to the learned counsel for the opposite party.
Urgent copy of your lordship.
Urgent certified copy as per this.
Grateful.
Yes, next call karantu.
29.
Mr. J.K. Rathore, senior advocate, along with Mr. A.K. Das for the petitioner, Mr. D.N. Rathore for the petitioner, Mr. Ansuman Sethi for the opposite party, 151.
Prabhu Prasanna.
Mr. Prabhu Prasanna Behra for the OP number 1. Mr. K.K. Swani along with Mr. J.R. Khuntia for the OP number 4 and 5. The matter being in the list for hearing under the heading for admission is mentioned by the learned counsel for the parties at the beginning of the day's proceeding. It is submitted that it is submitted by learned counsel Mr. Khuntia for the OP number 4 and 5 that the said OP shall file reply to the rejoinder filed by the petitioner. Stop. Mr. Khuntia seeks for the time. Accordingly, the matter shall be listed in the week for admission in the week commencing on 30/6/2026. The OPs 4 and 5 shall file their reply to the rejoinder and serve copies thereof. Upon serving copy thereof on the learned counsel for the state as well as the learned counsel for the petitioner. Yes, next.
Item 30.
M.K. Das for the petitioner, Mr. M.K. Ponda for the opposite party. Yes.
Item 30, I have a judgment copy. I have not with me. Apparently, sharp copy of judgment.
Lord, there are 5
Yeah, appeal memo
appeals
is-
listed today. 4 appeals the company has filed. I am appearing for the company, my lord, the project proponent. And one my learned senior has filed, that is LA 41. That is the second sub item. But all of these appeals are covered by your lordship's judgment. And in one of the appeal, 2 of the appeals, my lord, there are 20 to 25 my lord respondents. Some of them have already appeared through my learned senior, and some of them addressee left, and some other observations are there through SR, my lord. What my respectful submission is, my lord,
But if it is remanded, the learned trial court shall issue notice to the all the
and in the similar
because this
case, my
court
lord,
did not retain itself to hear everything.
my lord, that is my prayer. And
My
in the
lord,
similar circumstances, we have also filed writ petition by challenging the reference court's order. The land acquisition appeal, my lord, appeal is maintainable, but at the same time, the writ petition is also maintainable, and we have filed multiple petitions, writ petitions before the division bench. And division bench, my lord, you may mainly see without even noticing to the respondent.
Between the same parties.
Between the
Say
same
Hon'Ble
parties.
Sukinda.
Aଜ୍ଞା. Lordship,
ଆପଣ ତ ଆଜ୍ଞା ମିଷ୍ଟର ପଣ୍ଡା ଏଇଟା ତ ଆପଣଙ୍କ ଜମିଦାରୀ ଅନୁଗୁଳ ସୁକିନ୍ଦା
what happens, ma'am?
ପାରାଦୀପ ହରଦାସପୁର ତ ଆପଣଙ୍କ ଜମିଦାରୀ ସବୁ ଗୋଟେ
No, ma'am,
and it will be beneficial for the land users
what
because they will get the
They-
money if the final
What happens?
adjudication will be
The
there.
appeal memo, I have no judgment copy with me, also appeal memo in first case of you. Then let me
ଆପଣ ତ ସେଇ କେସରେ ଆପିୟର କରୁଛନ୍ତି ନା
Seଟା,
ଆରେ
ମାନେ
ସେଇ
judgment
ଫିଲ୍ଡଟା
ଦେଇନା।
କେମିତି ନେବେ
We have appeared pursuant to notice in appeal memo.
ଶୁଣିଲେ ତ ବୁଝିବେନି କଣ କହୁଛି ଆଜ୍ଞା ଆପଣ ଆଜ୍ଞା ଅନୁଗୁଳ ସୁକିନ୍ଦା କେସରେ ଆପଣ ହିଁ ଆପିୟର କରୁଛନ୍ତି
ଆଜ୍ଞା ମୁଁ ଅଛି ଦିଟା କେସରେ କମ୍ପାନୀ
ଇଏ ଅନୁଗୁଳ ସୁକିନ୍ଦା କେସ୍ ଯୋଉଟା ଡିସାଇଡ୍ କରିଛି ଏଇ କୋର୍ଟ
ଆଜ୍ଞା।
ସେଇ କେସରେ ଆପଣ ଆପିୟର କରୁଛନ୍ତି
ନାଇଁ ସେଟା କପିଟା ଦିନ ମୁଁ ତା ଦେଖିଦେବି ମୁଁ
ସେଟା ଆପଣ ତ ସେଇ କେସ୍ ଆପିୟର
ଦେଇଦେଲେ ମୁଁ ଦେଖିଦେବି
Is it
item 30, my lord?
I will take instruction.
Is it item 30?
Mr. Ponda, the concern is that upon the dekho to it,
সেটা ମୁଁ ଜଜମେଣ୍ଟ କପିଟା ମୋ ପାଖରେ ନାହିଁ
ସେଟା ମୁଁ ଯୋଉ କହୁଛନ୍ତି କୋଉଟା ମୁଁ କହୁଛି
ମୁଁ ଜଜମେଣ୍ଟ କପିଟା ମୋ ପାଖରେ ନାହିଁ
ଆଜ୍ଞା ମୁଁ କହୁଛି କଣ ମୁଁ କହିଲି ଦେଖନ୍ତୁ ଆଜ୍ଞା ଆପଣ କହୁଛନ୍ତି ସେଟା ମୁଁ କୋଉଟା
ଏଇ ଯୋଉଟା ଫାଷ୍ଟ କେସର ଅପିଲ ଫାଷ୍ଟ କେସର ଅପିଲ
ନମ୍ବରଟା ଦେଇ ଦେଖ
ଲା 52/2015
2015 ଟା ଟିକେ ଅନାନ୍ତୁ 11 ବର୍ଷ ହେଇଗଲା
ସେଟା
11 ବର୍ଷ ପରେ ମୁଁ ତାକୁ ଧରିକି ବସିଛି ଅଲ୍ଟିମେଟଲି ଅର୍ଡର ଇଜ ଆପଣଙ୍କ ଆକ୍ୱିଜିସନ କେବେ ହେଇଥିଲା
Malord, what happens first time?
What happened? Acquisition ହେଇନି ସେମାନେ କହୁଛନ୍ତି
This is listed malord before malord first time not early.
ଆରେ ମୋ ପାଖରେ ନୁହଁ ମୁଁ ମାନେ the court not in person of course ମୁଁ ଆଉ କଣ
mal ମତେ judgment
this matters should you must second point very important apart from this matter have been kept pending after pronouncement of the same parties you are the opponent project proponent is the appellant or in some cases you are the appellant and they are the opposite respondent. We can give you those citations also. Same Sukinda Railway Company and you are the other side.
That is there, my lord.
That is there. Now the question is that these matter how after 11 years can be kept pending.
What happens I am submitting? Let me serve a copy of judgment.
ମନା କଲେ ଦିଆ ହବନି ବୋଲି
ସେଟା I will examine and
ठीक है examine କଣ କରିବେ
ସେଟା ମାନେ ସେଥିରେ ଯୋଉ ଲୋକ ମରିଛନ୍ତି କେତେଟା କେସରେ ଲୋକ ନୋଟିସ ପାରିଛି
ନୋଟିସ ମୁଁ ୱେଟ୍ କରିବିନି ଆଜ୍ଞା
ଆଉ ବା କେତେଟା
ଦରକାର
ଜଜମେଣ୍ଟ
I cannot detain myself
ପୁଣି ଅର୍ଡରଟା ଦେଖି
when impugned order ଆଜ୍ଞା ପାର୍ଟି ନାହାନ୍ତି I will record your submissions
ଅପିଲଟା କରିଛନ୍ତି ତା କପିଟା ମତେ ଦେଇନାହାନ୍ତି ଖାଲି ମାନେ ଅପିଲ ମୋଟା ଖାଲି ଦେଇଛନ୍ତି
ଯେ ଆପଣ ସବୁ ନେବେ
ଅପିଲ ମୋଟା ଦେଇଛନ୍ତି ସେଥିରେ I will examine
ଆପଣ ଆଜି ନିଅନ୍ତୁ କାଲି ମ୍ୟାଟର ଲିଷ୍ଟ ହବ this matters cannot
ଆସୁ ସପ୍ତାହ ପରେ ସପ୍ତାହ ମାନେ ଟିକେ ପଠେଇବି ଲୋକଙ୍କୁ ପଠେଇବି
ଆପଣ ଯାହା କରୁଛନ୍ତି କରନ୍ତୁ ଆଜ୍ଞା you must look after the interest of the parties also ଆପଣ ଯାହାକୁ ରିପ୍ରେଜେଣ୍ଟ କରୁଛନ୍ତି ଆପଣ let us assume ଯେ ଆପଣ ବର୍ତ୍ତମାନ ଖୋଜାଖୋଜି କରିବେ କିଏ ଚାଲିଗଲେ you are just going on ମାନେ like a speaking toy କଣ ଆଜ୍ଞା କଣ ମୁଁ କହିଲି ବୁଝିଲେ କହିଲି ସେଟା ତାପରେ ଆପଣ ଯାହା ମୁଁ କହିଲି କଣ ବୁଝିଲେ then what is the difference between a toy and you ଆପଣ ଯୋଉ adjournment ପାଇଁ helmet ଆପଣ adjournment ପାଇବେ ଦିଆଗଲା ତାପରେ ଏଇ ମ୍ୟାଟରଟା ବର୍ତ୍ତମାନ ଆପଣ ନୋଟିସ ନେବେ ଚାଲିବ ରହିବ ଆପଣ ଖୋଜିବେ ଲିଗାଲ ହେୟାର ସବଷ୍ଟିଟ୍ୟୁଟ କରିବେ ସବୁ ଜିନିଷ ହବ ଅଲ୍ଟିମେଟଲି what is the direction that I was asking you
acquisition for primarily acquisition for railway is not come forward now company in some
I am just
railway should be necessary party
you are arguing the same point again and again before the same court which has already been I cannot ଆପଣଙ୍କର ମୁଁ ସେଥିପାଇଁ ପଚାରୁଛି ନା ବର୍ତ୍ତମାନ ଆପଣ ଟିକେ ଶୁଣିଲେ what will be the ultimate judgment ଯେ railway has not come okay railway has not come
ଦେଲେ କପିଟା ମୁଁ ମୋ ପାଖରେ ଜଜମେଣ୍ଟ ନାହିଁ ପୁନଟା ମୁଁ ଦେଇଦେଲେ ମୁଁ
ଦିଆ ହେଲା କପି ଆପଣଙ୍କୁ ଦିଆ ହବ କି ଆଡଜର୍ନମେଣ୍ଟ ଦିଆ ହବ
ମୁଁ ଦେଖିଦେବି ଦେଖିଦେଲେ
ଦରକାର ନାହିଁ ଆପଣଙ୍କ ଆର୍ଗୁମେଣ୍ଟ କଣ ଏଥିରେ ଆପଣଙ୍କୁ କପି ଦିଆ ହବ ସବୁ ହବ ସବଷ୍ଟିଟ୍ୟୁଟ ହେଇଗଲା ସବୁ ହେଇଗଲା ଅଲ୍ଟିମେଟ ଡିସିଜନ କଣ ହବ
ନେବି ଇନଷ୍ଟ୍ରକ୍ସନଟା ନେବି
କାହାଠୁ ଇନଷ୍ଟ୍ରକ୍ସନ ନେବେ
ସିନିୟର
ଜଜମେଣ୍ଟ କଣ ଆମେ ଆପଣଙ୍କୁ ଆଡଭାଇସ ନବୁ ନା ସୁପ୍ରିମ କୋର୍ଟ ଫଲୋ କରିବୁ ନା ଆମ ଡିସିଜନ ଫଲୋ କରିବୁ
ସେଟା
ଆଡଭାଇସ ନେଇକି କରିବୁ
ଏକ୍ସାମିନ କରିବି ଆଉ ତାର ଟିକେ
ଟୁମୋରୋ ଆଜ୍ଞା ଆପଣ ଆଜି ସର୍ଭ କରନ୍ତୁ
my lord I am just interviewing my lord the same matter railway is not included as a party so now a case this Elara court or any other court is money is disbursed by the railway now included as a party to this all the cases those are railway stake is there so my so yes so
by this division bench single bench one single bench then division single bench of mine then division bench now it has come
yes
so exactly that point I'm asking Mr. Ponda suppose you take notice
yes and this what is the outcome yes let's use correct trial court
you are saying that trial court
yes
what is there
if such order pass we don't have any objection also this will surprise our issue yes
if railway is implemented as a party that will not impact anyone's case or any manner because the reason being the 1995 constitutional bench decision
yes
that Mr. Ponda is not consulting he's consulting his senior he's not consulting the constitutional bench decision copy of the Mr. Mr. Sushant Kumar Das, along with Mr. Praveen Das, senior advocate, along with Mr. Praveen Das for the petitioner. You must understand, Mr. Panda, that speaks volumes about us, a court. A court, after keeping a matter pending for 11 years. And you see, the UP Awas Nigam is 1995. You have filed the application in 2015. 16/11/2015. How this court could have ignored that UP Awas and Vikas Nigam? Let us assume this court will take another 20 years. Doesn't lead anywhere.
That decision is clearly distinguished. What happened?
Clearly distinguished. Your distinguishing fact that Noida case has been dealt with. Noida padhile na gote bhul submission kale court re je distinguishable. Noida kahila the subsequent purchaser need not be made a party. That is clearly following UP Awas and Vikas Nigam. Noida does not say that Noida Development Authority will not be made a party. After the land is acquired, it is transferred to so many persons. Whether they will be made a party. Apanakar case la kehi party hebeni. You are arguing the extreme.
No, man, that is not my case.
Yes. Apanakar court party question dekhantu project proponent. Yes. Dekhun sitire. Siti achi. Kooti apana party korchun. Manoj Patnaik case re kooti apana party korchun. How party korchun?
Special land
pretension doesn't help. Special law is a state. They have nothing to do. They have received money and disbursed money. Now Mr. Paddy says that we are paying money. We have not been made party. So that has not helped you.
And Milord, interestingly, that Gregory Patrao judgment, that Noida judgment has been taken care of by the division bench. So that is helping the beneficiary only.
No,
that is helping the project proponent.
In fact, the
Lordship's judgment.
That I have taken note of.
Your Lordship has distinguished.
Because in the whole process, who is suffering? Mr. Ponda's client is suffering. I don't know why he wants his client to suffer.
And it is a time-bound procedure. Lordship has already directed that it has to be concluded.
I'm asking my client to give a copy of judgment.
You are most complex. None of us is complex. I'm unable to understand your submission. You are saying that I need a copy. You are given a copy. The matter will be adjourned. But what is your answer on that? Is that now in the reference matter you have not made neither railway party, now Mr. Paddy says, nor the company. And there is a direction to pay money. Who will pay the money?
Appeal is in the 15. What is the this I will take instruction.
Tomorrow. No, that is your choice, sir. Appearance kebe
appearance फाइल से प्रथम केस फाइल मा पार नाही सितमे
एतर ताले बहुत भलो कत
से सेकंड केस आजी पतन नाही सितमे मागुची अखी का लेनी
आपण आगे 23 रे अपियर करछन सो मो ऑर्डर पास करिबिनी एकना
हां तमे सेटा
आ ए जो 15 मैटरटा 23 रे अपियर करछन
23 से नोटिस फाइल
हां पण 23 रे
15 मासे हमें 23 रे अपियर नोटिस केबे गला नोटिस गला 23 रे जाईची
आपण आगे 23 रे अपियर करछन बुझी पड़नांती ओडिया
आज्ञा 23 रे अपियर
26 रे कोन कहछन म अपियर करनी बोली
ना करिज ना मु कहिर से मु कहि फास्ट केस रे म पार अपील मेमोटा नाही बोली कहली
नाही आगे सेटा आपण
सेटा फाइल नाही म अन
आपण जदी कहबे मु रेकॉर्ड कर देबी जे आपण अपियर करनी
दे देबे बोली केबे
कपड़ा ना मु दे दैट डायरेक्शन आई विल नॉट मेक दैट मिस्टेक और
मान लो व्हाट हैपेंस आई एम 70 जो अपील नोटिस करनी खाली अपील मेमोर दोछन जजमेंट कॉपी दो ना
आपण आगे आपण एलए 52 अपेक्षा करंतु तापर अन्य मैटर आर्ग्यू करी
ना सबुडा तो
सबुडा का नहीं सबुडा मु अपेक्षा ना मु 15 मसे मैटर आई
एम एक्शन टाइम आई एम एक्शन आई एम
यस यू लीव इट जजमेंट कॉपी यू मेड योर सबमिशन एंड रिकॉर्ड नो प्रॉब्लम मिस्टर मनोज कुमार पंडा फॉर R1 Prabhu Prasanna Behra.
Yes, sir.
So Prabhu Prasanna Behra, additional standing counsel for the OP R2. The coordinate bench by order dated 26/9/2022 had allowed the miscase number 218 of 2015 granted leave to file appeal by the project proponent, appellant Hon'Ble Sukinda Railway Limited. Pursuant to the issuance of notice, the respondent number 1 has appeared by filing Wakalatnama. Dated 7/8/2023, duly executed by Sri Manoj Kumar Patnaik, R1. The Wakalatnama bears the signature of the appearing counsel, Mr. Niranjan Panda and Mr. Manoj Kumar Panda. Today, the matter is listed for hearing under the heading for admission. The 18 June, 2024 that is by which bench? Can I say that the 3-4 decision है
My lord.
this order टा देखिए division bench रा.
My lord.
Copy टा नहीं.
My lord.
Submitted by Mr. Lord Counsel Mr. Ponda, appearing for the respondent one that adjournment may be granted to obtain instruction, as the Lord Counsel has to go through the judgment of the trial court. In view of the issuance of notice and sufficiency of notice, the prayer is not to be countenanced. The copy of the brief is also available in the paperless format. Moreover, the order that is going to be passed by this court will not anyway affect the R1, as similar matters have been allowed. Upon WPC 13949 June 24
That judgment is not with me. This is relying on that judgment.
Hon'Ble Sukinda আছে কি সেটা দেখ বার করলে লিখতে ডিএসডি এক্সামে দেখি মিস্টার পিকে পাড়ি এটা Mr. P.K. Paddy, senior advocate, along with
Mr. Milan Kumar.
Mr. Milan Kumar, CGC.
CGC.
Mr. Milan Kumar, CGC, for Union of India, for railways. It is submitted by the Lord DSGI. Mr. Ponnaka submission on its DSGI that in none of the matters where land has been acquired for railways is not a party. In the present application also, the judgment of the referral court as annexed to the writ application, that is
appeal.
That is LA miscase number that is annexed to the appeal, not writ application. Appeal, that is LA miscase number 75 of 2015, decided by judgment dated 28/10/2015, goes to show that the land user has only made the statutory authority special LAO as a party who is neither depositing the compensation, who is neither paying the compensation nor the enhanced compensation if it is allowed. It is submitted by the Lord DSA that unless railways or the project proponent are made parties and are heard, the direction to them for deposit of enhanced compensation would be contrary to the direction of the Honorable Apex Court in UP Awas and Vikas Nigam, so and so, as well as decisions of this court.
That is there, my lord.
Judgment copy. এটা
LA.
আচ্ছা কি হচ্ছে এটা?
অনুগুল সুকিন্দা রেলওয়ে লিমিটেড পিতাম্বর সাহু। অনুগুল সুকিন্দা রেলওয়ে লিমিটেড পিতাম্বর সাহু।
লেখালেখি উপরକୁ স্ক্রল অফ করো, সরি রাদার স্ক্রল ডাউন করো, পাঠে লেখা যাবে। আপনি তো ইন WPC নম্বর 13949 অফ 2002 হ্যাঁ 149 13,949 অফ 2024 কোলন ଦେଇକି ଲେଖିବେ ଅନୁଗୁଳ ସୁକିନ୍ଦା ରେଲୱେ ଲିମିଟେଡ କମା ଭୁବନେଶ୍ୱର ଭର୍ସେସ ଷ୍ଟେଟ ଅଫ ଓଡ଼ିଶା। Order dated 18/6/2024 passed by the division bench. The learned counsel for the appellants refer to the writ petition WPC number 6498 of 2026, which has been disposed of by order dated 20/4/26 by the division bench, again by the division bench, by order dated 20/4/2026. ଏଥିରେ ଆପଣ ସିଙ୍ଗଲ ବେସ୍ ଟାକୁ ରେଫର କରିନାହାନ୍ତି?
No, my lord. ପିତାମ୍ବର ସାହୁ।
ସିଙ୍ଗଲ ବେସ୍ ଟା ରେଫର ଆପଣ ଅଛି, ରେଫରେନ୍ସ ଏବେ ଅଛି?
Yes, my lord. This honorable court judgment, my lord. That is
Okay, just let me come. I have not gone that far. The Lord, it is submitted by the Lord counsel for the appellant that as writ petition is also maintainable, the division benches have entertained the writ application and disposed of. Remanding the matter before the Lord Civil Judge Senior Division, who had considered the reference. The cited decision, the cited order dated 20/4/2026 in WPC number 6498 of 2026 is reproduced herein, or the relevant paragraphs of so and so reproduced herein. Para 4, 5, 6, 7, 8, 9, para 4 पूरा शेष पर्यंत 12. Item कितने इटा होचे item 50. The prayer of the respondent not to urgent the matter is also not to be entertained in view of the fact that the land acquisition appeal is filed, was presented before this court on 16/11/2015. The reference was answered by judgment dated 17/10/2015 by the Lord Civil Judge Senior Division Kamakhya Nagar. In the reference, neither the railways nor the Hon'Ble Sukinda nor the project proponent Hon'Ble Sukinda Railway Company were made parties. It is further submitted by parties. The matter is kept pending for the last 11 years without proceeding any further. The learned counsel for the opposite, the respondent one, therefore submits that The constitution-based decision in EP Abbas এবং বিকাশ পরিষদ versus জ্ঞান দেবী AR 1995 SC 725 is distinguishable. In considered view of this court, the said submission of the learned counsel for the R1 has already been considered by this court in LAA 33 of 2014-14 with the FNS citation because I find my decisions are not reported. In one of the lawsuits, I find that since last 2 years, I have not rendered any judgment.
No, but we have used this judgment before. This one.
No. Reference is often difficult.
That is true.
So nothing wrong there.
ଭିତରୁ ପଶି ନଥିବେ କି ମାନେ actually seriousness of the judgment may not be
so and so I ମାନେ ILR हमको ये से ILR भी ଏବେ ବନ୍ଦ ହେଇଗଲା ବୋଧେ
ନା ଏଟା ବନ୍ଦ ହେଇଗଲାଣି କିନ୍ତୁ ସେ decision ର seriousness of the judgment may not be diluted by anybody ସେଟା ବି ହେଇଥାଇପାରେ
lighter vein
କିନ୍ତୁ ଏଟା ଦରକାର ପଡିବ ନା ବର୍ତ୍ତମାନ
the Panda is so serious so when you do not find any judgment for the 2 years, the impression would be that he doesn't render, the court doesn't render any judgment.
What happens? ILR bond hବା ଫଳରେ we are suffering a lot.
So ILR ଆଜ୍ଞା ଯୋଡେ ହେଇ ପଡୁଥିଲା ପୁରା ଅନଲାଇନ ହେଇଗଲା ମୁଁ ଜାଣିଛି ଆପଣ 300 ଟଙ୍କାରେ ପାଉଥିଲେ ଯୋଉ ତ ଆଇ नो
ବଢେଇ ଦେଲେ ବି ଚଳେଇଲା
the purpose was for that only
ପୁରା ପୁରି ବନ୍ଦ କରିବା ନଥିଲା
तो ସେଇ କଥା ମୁଁ ରେଫର କରିବା ପାଇଁ ଏଥିରେ I think this has been reported ILR ହେଇଥିବ କାରଣ ସେତେବେଳେ ILR ଥିଲା ଆପଣ AR ଯୋଉ AR ଅନଲାଇନ ଦେଖୁଛନ୍ତି ଓଡ଼ିଶା AR online Odisha has been launched since last about 2 years खंडे हबो but again print format रे न आसले बोधे सेटा एते पॉपुलर हे परनी हो but it is there.
I didn't have knowledge. Yes. ମୁଁ ସେଟା ଜାଣି ନଥିଲି ତା ଦେଖିବା ତାହେଲେ ଏଥର
print ନହେଲେ ତ actually there is some ଯେତେ ଯା electronic format ହେଲେ ବି if it is not printed
you cannot follow us. Our generation it will be very difficult. The young generation they are ठीक से पिला follow कर राजी नहीं କିନ୍ତୁ ଆମକୁ ଅସୁବିଧା ହେଉଛି
considered and answered in judgment of this court dated 33 of 2014 dated 5/5/24 judgment dated 5/5/25 passed in LAA 33 of 2014. That is Ramesh Chandra Patra versus Special LAO Hon'Ble Dugri Sotinda New Broad Gauge Rail Link Project.
Para 20 milot.
20.
That is 20.
Para 20 of Ramesh Chandra Patra Supra. Para 20 रो आपको लगता है 18, 19, 20.
Para 35 onwards. Lordship has decided on this issue. 35, 36, 37, and 38. Up to 39.
35
to 39.
up to 39.
Yes.
Stop. ରମେଶ ଚନ୍ଦ୍ର ପାତ୍ରଟା ଅଛି ଆପଣଙ୍କର ଦତ୍ତବାବୁ ପାତ୍ର ଆପଣ appearance ଫାଇଲ କରିଛନ୍ତି ଆପଣଙ୍କର CGC ଅଛନ୍ତି
ଆଜ୍ଞା ହଁ ମୁଁ ମାନେ on the way he is reaching the court, my lord. Within 2-3
so I'll
minutes.
record
Yes.
that.
Yes,
Okay.
yes. I'll pass on a slip, my lord, along with different cases, then I may be prepared. Yes.
As a in view of the above judgments of this court as well as the Honorable Apex Court, the award dated, the judgment dated 28/10/2015 in LA miss case number 75 of 2015 rendered by the learned civil judge into bracket senior division Kamakhya Nagar is set aside and passed. The LA miss case number 126 of 2013 is restored. The LA miss case number 75 of 2015 is restored to file for adjudication afresh. The parties in the present case, that is the appellants and the interveners. Upon intervention file question na kori nahanti?
No, we are not filing the change.
Okay.
We intended to file, yes.
The appellants, the R1, R1, respondent number 1, the state as well as the Ministry of Railways.
Ministry of Railway.
As well as the Ministry of Railways.
Yes.
Shall appear before the learned court.
Let's me specify also Southeastern Railway. Let's me specify that.
Ministry of Railways.
Stroke Southeastern Railway.
Southeastern Railways or East Coast Railway.
Sorry, East Coast Railway. East
Coast Railway.
Yes.
Shall appear before the learned court of jurisdiction, that is the learned civil judge into bracket senior division Kamakhya Nagar, or any court that may be assigned the matter. The learned court shall act upon production of the certified copy of this order. The present appellants as well as the railways public Union consider Ministry of Railways oblique East Coast Railway.
Yes, my lord. Yes.
Shall file application for impletion as necessary party before the learned referral court in the said proceeding or in the proceedings which stands restored.
Yes. Yes.
The learned court shall allow application, the said application to enable the interveners to be arrayed as opposite parties.
Yes.
1 and 2.
Yes.
As the opposite parties. Then para. As the matter is remanded to the learned referral court for adjudication afresh, the court shall afford an opportunity to the intervener, the project proponent as well as the railways oblique East Coast Railway to file their written statement regarding the enhancement of the award, and shall also allow them to adduce evidence and produce witnesses in accordance with law. The present appellant shall also appear, the present respondents, the present respondent number 1 shall appear. Appear, legal here na nahi sir, jani nahi apna koti. shall appear. If the respondent do not appear, the court shall issue notice giving them reasonable time to appear again. ଆପଣ କେବେ appear କରିପାରିବେ? ଛଅ ସାତ
ସାର୍ଟିଫିକେଟ କୋଟା ନେଇକି ଦାଖଲ କରିବି।
The parties shall appear before the learned. All the parties are directed to appear before the learned court in season of the matter. Public learned civil judge so and so so and so. Learned civil judge into bracket senior division Kamakhya Nagar on. चित्र भी एक साथ हो, चित्र भी एक साथ रहो और एक के साथ है
2024
24 तेरा अमाउंट डिपॉजिट हुई थी
एक साथ 24
अमाउंट रेलवे दे दिए एक्विजिशन ऑफिसर को
डिपॉजिट हुई थी कौन मुझे जाना नहीं
ना
पर खाली पारा 44 जोटा अच्छे से जजमेंट लेते हैं क्लैरिफाइड मुझे अपन को डिक्टेट करी थी आई हैव डिक्टेटेड फ्रॉम द माय अर्लियर जजमेंट इन 40 41 42 देन 44 44 and 45 46 40 44 45 LA 41 होची speaking enhancement
enhancement
the same order
हाँ same order yep same order same
53 होचंती आपण
my application
Mr. Padhi
yes
LA 41 फाइल करचंती लैंड लूजर
आया
so same
so
order
which yes same order because whichever case you required to be implemented as a party yes
okay LA 53
also yes
also same and nowhere railway is party as also the project
62
project 56 50 62 63 all yes
separate done करे थोड़े पकुड़ा को रखे जाते हैं ना फ्री
Lord, I have extra copies.
right और रेफरेंस नहीं है रेफरेंस लेके करेंगे
I request my friend if you will provide a copy it will be helpful to me
My lord,
if you have agree हाँ online ले देले भी चलिए online ले
ଆପଣ
देले
अपील मेमो
हाँ apple memo टा
I'll do that.
अपील मेमो
I'll do that.
ଏଇଟା ମୁଁ ଆରମ୍ଭରୁ କହୁଥିଲି ସେଥିପାଇଁ ମାନେ
अरे mail ले दे दे काहे व्यस्त हो जाओ
सर ଆପଣ ଭାବନ୍ତୁ ଆପଣ ଆହୁରି 10 ବର୍ଷ ପରେ ମୁଁ ଏ ଅର୍ଡର ପାସ୍ କରିବି
ନେକ୍ସଟ ୱିକ୍ ରେ
ମତେ ତ ଆଜ୍ଞା ଖରାପ ଲାଗୁଛି
ଏଇ
ବର୍ତ୍ତମାନ
ଅର୍ଡରଟା ହଉ ନେକ୍ସଟ ୱିକ୍ ରେ ହଉ
ଆଜ୍ଞା 15 ମସିହାରେ
ଆଉ କଣ it is surprise our problem yes
ସେ ମାନେ ଆଗରୁ ସବୁ ସିଷ୍ଟମ ଥିଲା ଖାଲି ଅପିଲ ପଠଉଥିଲା ଜଜମେଣ୍ଟ ପଠଉନଥିଲା ଏବେ ନା ଅପିଲ ଉଇଥ୍ ଜଜମେଣ୍ଟ ଯାଉଛି ତେଣୁ ସେ ଖାଲି
ପେପରଲେସ୍ କରିଦିଆଗଲା we should have some reasonable regard to the time ଆପଣଙ୍କର ଗୋଟେ ରିମାଣ୍ଡ କରିବା ପାଇଁ ଆମେ ନବୁ 11 ବର୍ଷ
ଫାର୍ଷ୍ଟ ଟାଇମ ଆସିଲା ଏଇଟା ଦିଶେ ଫାର୍ଷ୍ଟ ଟାଇମ ଆଗରୁ ତ ଆସିନଥିଲା ତେଣୁ ଟାଇମ ନେଇନଥିଲା
Mr. Das you serve copies
My lord, I'll serve.
ଆପଣ ବି ସଫ୍ଟ କପି ଚାହିଁବେ ରେଜିଷ୍ଟର ନେଇ ପାରିବେ
हाँ yes yes
I'll do that.
yes
मैंने one of my sister is there court he sleep pass on the sleep for dependent council or she
ସେଟା ଆପଣ ଦେଇଦେବେ କୋର୍ଟ ମାଷ୍ଟର
आगे
ଯଦି ଆପଣଙ୍କ ଦରକାର ନାହିଁ ଦେଇଦେন ସେ ପରେ ଫେରେଇ ଦେବେ ଆପଣଙ୍କୁ ଆପଣ ସେ
My lord,
କପି
copies of the judgment. I have extra
ଫାଇଲ
copies.
ରଖିଦିଏ ରଖି yes
31
31 to 39 we cannot now open briefs. Our time is already over. In 5 minutes, these are all hearing matters. So, if you want any matter to be, all matters will be in the list after vacation. Okay.
this is
Again?
My lord, item 31.
There is a stay in the. I have filed IA for vacation of stay because of.
In a after notice matter, it has to be heard.
My lord.
Without hearing, after I have stopped taking up matters because of paucity of time. So going to that day, some day after vacation. 31 केबे डेट करती हूँ आपण केबे चाहुछन
If matter will come next week.
next week रे ही परिबने से because we are trying to take stock of how many matters are exactly
Because
listed.
my lord, my prayer is if the stay is not vacant, then we're not getting any.
Maintenance दउनांती
Yes, ma'am.
आपण 3 वर्ष होला सेमती करिक रखिछंती कोन कराची सडनली तो 4 वर्ष हे गला. Yes.
Your Lordship, I can provide Your Lordship with the bank statement. We have been making regular payments from last year of May to December. We have been making regular payments, Your Lordship.
Can appraise your learned friend? Maybe it is his instruction, but 31 केबे आनिबे बंधु
वो कौन सी 6-7
6-7 32 anyone there? पानी गिरे सर तो बंद चली गयो 32 गोटे केबे डेट कर दियो तो हैला 33
wife, my sister has sought for transfer from Jaspur to Puri in both the cases. We have talked that the Kotak will be the middle point. It will be more convenient for both parties.
Kotak केले हबो. Now the crucial question is memo देबे ना नहीं मते मु ऑर्डर कर देबे कोटा
Lordship can.
ठीक अछि कोटा कर देबे एटा डिक्टेशन दो पड़े
ଗୋଟେ modification କଣ
modification ଆଉ ଗୋଟେ amendment
तो डिस्पोज ऑफ हेला कोन
mistake ଅଛି
अच्छा
से फैमिली कोर्ट पूरी है जाइतला इंस्टेड ऑफ एसडीएम पूरी सेटा दैट मे बी अलाउड
करेक्शंस विल बी कैरिड आउट आईए रे करेक्शन कोचन तो 33 आपनकर 30 डिस्पोज ऑफ 33 आल्सो डिस्पोज्ड ऑफ बोथ
Your Lordship, item number 39.
just one by one 34 डेट कर देगा 35 क्वेश्चन डिक्टेशन दो पड़े ठीक है then 36 Mr. Bose.
Yes, my lord. Here I am seeking transfer of the guardianship miscase from the judge family court to judge district judge.
तो said कि अछंती
Yes, notice was there that they have appeared.
तला आ गोटे डेट को रहू
सर एठी कोन हेछि कि आपण आईएस टीआरपीसी संगे आईए रो नोटिस हेतला सर डिस्ट्रिक्ट जज माने फैमिली जज रो गार्डियनशिप मिसकेस सुनिवार पावर नै इट इज ओनली द डिस्ट्रिक्ट जज हु विल हियर द फैमिली जज कैनॉट हियर बिकॉज इट्स अ क्वेश्चन ऑफ गार्डियनशिप अपॉइंटमेंट ऑफ गार्डियन so my lord if other side is not here I'll file an application for adjournment him defer because it is posted to Monday and 12th it is posted my lord and
the matter being in the list it like a paucity of time intervenes matter being in the list could not reach it is mentioned by the learned counsel for the petitioner outre padile matter being in the list for hearing under the heading for admission could not reach then and is mentioned by the learned counsel for the petitioner. He submits that the matter before the learned trial court shall be adjourned during pendency of the present proceeding. Stop. Agur kichi order hai
no sir
sir I had directed so and so it is directed the guardianship case 169
yes ma'am
na CS 1590
no sir eta guardianship
case 169 of 2025 pending before the learned judge family court Noyagada shall be adjourned beyond the date adjourned beyond 13/7/2026 the matter shall be listed for orders in the week commencing 6/7/2026
Urgent copy of your
Upon a
lordship.
prayer being made for the said purpose. Shall be adjourned. You have to take prayer as services. Upon a prayer being made for the said purpose, the matter shall be listed in the week commencing for orders in the week commencing for Sahoo Curations. Yes.
Urgent copy of your lordship.
Yes. Precedent date is 3839.
Lordship, item number 38.
Yes.
My lordship, this is a transfer petition case. Lordship may seek an adjournment, but my lordship, IA may be continued.
You want a date?
Yes, my lordship.
After vacation, I have an
Yes, my lordship.
38 date कर दियो.
We comes in 13.
Yes, my lordship, IA may be continued.
अच्छा,
For the stay of civil.
এটা कितने कल 38.
38.
Order as in 36 of.
Your Lordship, item number
38 रे ଗୋଟେ line add ହବ that the Honorable Council refers to the order dated 26/3/2026 and 6 and 6 extension of the interim direction. Yes, please.
Your Lordship, item number 39. On
Yes.
behalf of my senior Amitabh Das.
Yes, sorry. ଆପଣଙ୍କ appearance ଟା ଆପଣଙ୍କ ନାଁ sir?
My name is Swagat Pati.
Swagat Pati.
Yes,
Mr. Swagat Pati on behalf of S. Bhuya for the petitioner. Opposite party blank. Opposite party के नाम क्यों? Blank रे mention करछो. Yes,
Your
madam.
Lordship, item number 39. On
Yes.
behalf of my senior Amitabh Das. Your Lordship, he wants to remove his name from opposite party number 1.
Say order.
He is no more appearing for NHAI.
Acha. The 39 item being in the list is a paucity of time intervenes. The matter being in the list for hearing. For hearing, the court could not be taken up. Could not reach. Could not reach. It is mentioned by Lord Council.
Priyadarshini Mahapatra.
Ms. Priyadarshini Mahapatra. She submits that name of Sri Amitabh Das, senior advocate, be deleted from the cause list as well as the case brief, as he has no instruction to appear on behalf of the National Highway Authority of India. Stop. Registry shall do the needful regarding withdrawal of the power of withdrawal of appearance of Lord Council Sri Amitabh Das and Associates.
Obliged.
এটা কেবে লিস্ট হব চাହୁଛନ୍ତି না ଆପଣ ଆପଣ ତ କିଛି
I am for the appellant.
ଆପଣ ଆପଣ ପିଟିସନର ଭାଇ
Yes, but I am for the appellant.
ମୁଁ ଅନଉଛି ଯେ ଆପଣଙ୍କ ଆଚ୍ଛା ସରି ମିଷ୍ଟର ଆପଣଙ୍କ ନାଁଟା ସାର୍ ହଉଛି ମିଷ୍ଟର
Debasi Sahu. Debasi Sahu.
ମିଷ୍ଟର ଡି ସାହୁ ଫର ଦ ଆପେଲେଣ୍ଟ ଏ ଯୋଉ 38 39 ରେ କେବେ ସାର୍ ମିଷ୍ଟର ସାହୁ
After vacation.
the matter shall be listed for hearing in the week commencing 20/7/2026
I am limited.
ଆଜ୍ଞା
Prior to this.
ଆଜ୍ଞା ସେଇ ତ ଆପଣଙ୍କର ଫାଷ୍ଟ ୱିକ୍ ଛାଡ଼ିଲେ ଆଚ୍ଛା ଠିକ 13/7 ଆଉ କଣ ହେଇପାରିବ ଆପଣ 3ଟା ୱିକ୍ ଭିତରେ ମ୍ୟାକ୍ସିମମ୍ ମ୍ୟାଟର ରହିଛି 13/7 ରେ 42ଟା ମ୍ୟାଟର ଅଲରେଡି ପାଖାପାଖି 50ଟା ରହିଲାଣି। So if you look at that.